Good afternoon. Welcome to a meeting of the California Paraprofessional Program Working Group. I can begin by taking roll. Bashan, Brynelson,
Present.
Belmuth,
Here.
Fleischman.
Here.
No, Stephen Hamilton is not expected. Judge Harper is expected to be late. Hardston.
Here.
Kirkmeyer.
Here.
McRae.
Here.
Olvera.
Here.
This is Petru.
Here.
Robinson. Judge Rubin.
Here.
Shining.
Here.
Sarouche.
Here.
Spiro.
Here.
Torres Ambris.
Present.
Judge Wiley.
Present.
And I believe Judge Yu is expected to join us later.
Correct, she's delayed. If we could take the PowerPoint down, please.
Yes.
And Leah, I believe you're here, correct?
Yes.
Okay, if you could please just give us a couple of minutes on how we're rejiggering the schedule this afternoon.
Okay, so we're starting with program evaluation with our guests from the National Center for State Courts, Paula Hannaford, and University of Utah, Anna Carpenter. And I think Anna, one of your colleagues, is with you as well. And then we will move into the rules discussion. So, and I think the rest of the agenda will follow, but we're just switching
And
out.
so we are going to go ahead and start with our guests, because again, they are on East Coast time, where it is already after 4 o'clock in the afternoon and have end of the day commitments. So we're going to begin with them, and then we'll pause to take public comment at that point, and then roll into the rules regulatory discussion. So first of all, welcome to everyone. Thank you very much for joining us this afternoon. We appreciate it greatly. And Leah, I think you were in whoever was in contact with them, if they could take the lead, that would be great.
Yes, sure. So Paula, Alex, and Anna, could you please introduce yourselves briefly? And while they're doing that, Linda, maybe you can put up the one slide that we prepared for this discussion before we turn it over to Paula.
Well, good afternoon, everyone. My name is Paula Hannaford Agor, and I am a principal court research consultant with the National Center for State Courts, and have been working in some of the areas around regulatory reform for the last couple of years.
Hey everyone, my name is Anna Carpenter. I'm at the University of Utah College of Law, and I wear a teaching hat, which is as a clinical faculty member. So I'm actually a practicing attorney, not just an academic. And then I also have a scholarly hat where I study the civil justice system, including regulatory reform and the development of paraprofessional licensing programs.
Hi, I am Alex Mark. I am just an academic who is an assistant professor of government at Wesleyan University. Anna and I have been working together for quite a while, so she can take my gentle ribbing. I am really excited to be here because, as Anna has mentioned, we have been working on research in this area and are looking forward to hearing about what you all are working on. Thank you.
Great, thanks. Carolyn, did you have your hand up?
No, I just assume public comment from the participants who are attending is going to happen afterwards. And do we have an estimate on time, because they're all generally working attorneys and paraprofessionals, or I'm sorry, paralegals and such?
Yeah, I think it will happen within 45 minutes to 1 hour.
Thank you.
Okay, great. So I just put one slide together, going through notes and listening to various meetings that we've had where we've talked generally about some of the ways that we might like to evaluate the program. So none of this information on screen is new. Hopefully it'll ring a bell with all of you, but it's certainly just ideas that have come up over the course of our many meetings and discussions about ways that we might determine that the program was successful, and data we might want to collect to assess some of the topic areas listed on the left-hand side. I shared this with Paula and Anna because I wanted them to get a sense of kind of the brainstorming you all have done, and to the extent possible, be able to speak to some of these data points as they do their presentation. So we're going to start with the National Center because they have promulgated not one, but a couple of frameworks for evaluating access to justice type of legal services programs akin to the one that we are establishing here. And I've sent you both of those frameworks to take a look at. And I think the one I sent out on Friday is the one that Paula will really be digging into today. And then we will hear from our Utah folks who are currently doing an evaluation of the Utah triple LT or licensed paraprofessional program. So with that, I would just kick it over to you, Paula. And do you have a PowerPoint you want to share with us?
I do, if that's okay.
Yes, I think Linda can set that up for you.
All right. So hopefully everyone can see this. And I'm really delighted to be here this afternoon and to be joining you. And I'm actually so delighted to hear you talking about actually doing some evaluation and thinking really strategically about what you would want to measure and how you would actually collect the data ahead of time. As opposed to retrospectively when you discover that you haven't actually put together an infrastructure for being able to do that, which is a too common mistake that a lot of people make. So Leah had actually asked me to talk about two things. I think she sent both of these to you. One is just sort of a think piece that I did with Tom Clark, who was the former vice president of the research division here at the National Center for State Courts, mostly for institutional supporters and funders of access to justice programs of different types. We could be talking online dispute resolution or what we're talking about for these types of alternative legal providers, ALPs, or it could be, online tools, navigators, any type of legal services provider type that is intended to increase access to justice. The second one is a specific set of measures that we've developed for these allied legal professional programs that are very definitely targeted to these. I hate to define anything as an alternative to a lawyer because it's just really unfair to just say not a lawyer. But essentially, there are different models that are being developed by Utah, the Washington State Triple LT, the New York State Navigator program, going under a number of different umbrella terms. And so we've just, for the purposes of this report, just decided to come up with a completely new acronym and calling them ALPs, Allied Legal Professionals. So I wanted to start, first of all, with the piece that Tom Clark and I did. And this is, if any of you are familiar with the Drake equation, it was actually an astronomer in the 1930s who developed a formula for predicting what was the likelihood of there being intelligent life in the universe besides humans. And it was sort of a series of, it depended on the number of stars in the galaxy and how many stars were actually supporting planets and which planets were capable of supporting life and what was the likelihood that life would have developed. And so depending upon how you actually set up those parameters, you could sort of say either, well, of course there's intelligent life, or no, there's not, depending upon how those assumptions that you built in. So this has been sort of floating around with a couple of other folks, and this was a piece that is actually a refinement of some earlier work that was done that Tom came up with and I helped with a little bit. But this was pretty much the formula that we thought, and I think it's useful as you are designing your paraprofessional program to be thinking about how large or small of an impact are you actually anticipating. And so the formula is actually looking at sort of a series of assumptions. Who are the anticipated users? How large of a population is that? These anticipated users, how will they actually know that they have a legal problem? And if they actually understand that they have a legal problem, because one of the things that we know about access to justice is that a lot of people recognize that they have a problem, but don't actually understand it to be a legal problem for which legal services can be potentially helpful. Do they want that assistance, and will they actually find this program that you are putting out? If they do discover the program, can they access it? Can they afford, if there are any costs involved? If they are limited English proficiency, are the program services offered in other languages? Are they offered to persons with disabilities? If it's something that is sort of an in-person, are there transportation costs? Where are the services located? What hours are they being offered? So really having to do with the accessibility of these services. And then finally, and this really goes to the quality of the services, if they do, successfully access the services, will they benefit from them? And a lot of that goes with how are you defining benefit? And this is, very generic across all of these different types of access to justice programs. So maybe they would benefit because they actually have an improved understanding of what their legal rights and responsibilities and obligations are, and what are the implications of different decisions that they could make. Maybe they benefit by just having reduced costs as compared to having to hire a lawyer. Maybe they have improved outcomes in terms of whatever their legal situation is. And perhaps it's defined by increased, procedural satisfaction, litigant satisfaction with how they were treated in the process. And so sort of logically, as you go through these, you start out with a targeted number that's actually a whole number, and then you sort of work your way through in percentages. So out of that targeted number, a certain percentage will discover it, a certain percentage of those will access it, a certain percentage of those will benefit. And so you end up with basically a ratio of how big is the gap. A couple of really interesting sort of things about this is that you can actually have a really big impact focusing further upstream of thinking about who is your targeted population, and can they actually find it and access it. And so this sort of framework, and you can read the report and sort of figure out how to use the percentages as you go through, and sort of what some types of assumptions that you want to make about your paraprofessional program. But the second report that we did, I will say that the National Center had received a grant from the State Justice Institute to do an evaluation of the Washington State LLT program. Unfortunately, we discovered as we got into it that they had actually not put in place some of the infrastructure needed to do that evaluation. So we were unable to do it. And then, of course, even as we were, trying to plan sort of an alternative approach, the Washington Supreme Court decided to sunset the program. And so we basically switched gears and said, well, why don't we just publish an evaluation framework for how we would have done it if we had had the opportunity and the infrastructure in place to be able to collect the data. And the first part of it, we actually talk about considerations for designing a program that really had this framework that Tom Clark and I put together in mind. And so this one section talks about sort of what are the things that you should consider when you are designing a new program to produce these allied legal professionals who will provide legal services. And so part of it is just thinking about for whom is the program targeted. In Washington State, they were targeting it around family law and self-represented litigants. There was actually not a lot of clarity, I think, with the program designers of whether it was going to be targeted to people who were very low income and would not be able to afford any could not get any legal services, or whether it was middle income with people who could pay something for legal assistance, but wouldn't necessarily qualify, for example, a legal aid program. And so that is sort of part of that question that we get to of like, who are you designing this program for, and being very clear about what is the actual end in California of people who could potentially benefit from this program. The next one is really going around, again, sort of, if you're targeting this, is the program itself designed to meet that need? And so a lot of the questions in terms of what are the qualifications to even apply to be an allied legal professional? Are they broad enough that you can recruit enough people to potentially begin to meet the demand for services? How do you recruit people and let them know that this new professional opportunity is available? How long will it take for people to get through the pipeline to get certified? And of the people who are going through that pipeline, what percentage of them will eventually be certified? Or are you going to have a fairly large dropout rate because your certification process is too stringent? And part of it is how much of an investment is a person actually going to have to make, both in terms of time and tuition costs, or testing costs, in order to become certified. So these are all sort of going into that thing of, are you actually thinking strategically about how you design your program so you actually have enough paraprofessionals to begin to meet the demand. The other part of it, and this came out of some of the focus groups that we did with Washington State triple LTs that I think is actually really important, is on the professional development and support. Are you institutionally advertising or helping these folks advertise their market, their services in a way that they can actually, attract clients to be able to meet this need? That was one in the Washington State Bar, which, like many state bars, has a fairly robust lawyer referral service and local bar associations, and people could actually come together and get referrals and have all sorts of advertising for this. But they did not actually develop any resources for the triple LTs to be able to do that same type of networking and referral services. So they were pretty much, putting up their own shingle and starting out and having to put together their own business plan for how they were going to do advertising and attract clients. And that was very difficult for many of them with a completely new profession that nobody had ever heard of before. The last one really goes to just sort of the governance and external support. If you've been paying any attention, it was highly controversial in Washington State, and I think the conventional wisdom was that essentially the organized bar, particularly the family law bar, never liked it, considered it to be extreme competition, and eventually convinced a new composition of the Washington Supreme Court that had originally approved the program to sunset the program last year. So I would ask you to sort of, using the Clark and Hannaford-Agor framework and some of these considerations as you're putting together your rules and thinking about it, that these can be very helpful for getting some assessment about whether or not, in fact, the program, from a process evaluation standpoint, is actually designed to succeed. So that's just one area to think about. Then the other one, the exact performance measures that we put together, is something that we did that we've actually done with a number of things, and trying to keep in mind that there are a lot of different stakeholder perspectives that are really important. And so we took what we called the balanced scorecard approach and developed essentially a series of what we're calling 8 fundamental measures, as well as a number of supplemental measures that are intended to look at these different perspectives. So you can see sort of our diagram here. There are a vertical and a horizontal axis. The horizontal axis is the micro and macro axis. And so on the left-hand side, we have the micro, and that's really looking at the individual client, individual case level, as opposed to the macro level on the right-hand side, which is the which is sort of a larger, more systematic approach of looking as the overall system working, the ecosystem of the justice system. Then our vertical axis is our external and internal axis. And so the external is really looking from the client and public perspective of the program and the services that are being offered by allied legal professionals. And the internal is looking at it from, primarily we tended to look at it from the court perspective, although with allied legal professionals, it's not all legal problems require that you go to court. So depending upon who the program is intended to serve, it may actually be state administrative agencies, workman's comp. It may be federal courts, it may be Social Security, federal agencies, Medicaid, any of these things that are sort of, legal problems, but not necessarily involving courts. So the internal is looking at the efficiency, both the efficiency of how the case itself individually is being handled, as well as how efficiently your program is actually producing ALPs. The internal is also more along the lines of a sustainability from an institutional perspective, and that could be both the economic sustainability of the profession writ large. If you can get people certified, can they actually make a living? And the political sustainability, is there enough public legitimacy about this new legal role to be sustainable in the long term? So I'm just going to go through some of the fundamental measures and what we came up with. This is sort of a first cut as some of these programs are starting to roll out, both in, we've had Washington State up for a while, Arizona, Utah, California now, and I think North Carolina is also planning to move forward on a similar type of program. So our
Paula, this is Leah. I'm just going to jump in because I know that you have a time constraint. And I want to make sure we can hear from Anna and that we have time for questions. So
Okay.
just to the extent that you can roll through these fairly quickly, I would appreciate that.
I will definitely do that.
Okay.
So our external micro, this is really at the client level. Fundamental, can you actually say what the disposition is for the case? And then the other one is outcome favorability. We let this as supplemental because a lot of court data systems do not necessarily tell you who won. They just say, was there a judgment, or was it dismissed, or was it settled? We also look at client satisfaction, but there is also sort of the idea of the client fees. Do you actually know how much they paid? And how transparent is the fee structure for clients using it? Our external macro is really looking at, is there an increase in sort of representation as fundamental, as well as compliance with court orders? Sort of this idea that if it's working the way it should, court orders or whatever the outcome should be stable. that the client themselves and the public actually views this as a legitimate outcome. And supplemental is just really looking at representation in underserved populations, equity, public trust, the diversity of the court user population. Our micro-internal, the fundamental is time to disposition. So just beginning to end for the case. And then also looking at the allied professional training does the training actually train people for the tasks that they are being asked to do? Or are they being trained in things that they don't actually need to know because they are not asked to do it, or are there large gaps of things that they do have to do that they're not being trained in? Supplemental is just sort of go through some of these of just costs, number of proceedings. Are attorneys actually getting to work on sort of at a higher level on their license, because some of the more rote work that can be done by allied professionals is now being taken up there. Same thing with court staff time, especially people in self-help areas. Are they working with a more informed group, or at least better able to concentrate their time on self-represented litigants who can't afford ALPs? And then our last one is the internal macro sustainability area. So fundamentally, are ALPs able to make a living working in this profession, as well as the perceived role legitimacy from outsiders, whether it's judges, lawyers, and the public. And supplemental is sort of the market coverage. Are ALPs actually covering as much of a market as that you were hoping that they were? And the perceived market threat in terms of political sustainability. Are you possibly looking at a repeat of Washington State? So that's all I had, and I will now happily turn it over to Alex and Anna.
Well, let me just pause and see if folks want to ask questions now or wait until we hear from Utah. I see Amos has his hand up. I'm wondering, before we go to Amos, Paula, could you just quickly explain the difference between fundamental and supplemental?
Yes, so the fundamental, these were ones, and we're actually really hoping that as these different programs roll out around the country, that we can have some cross-state comparison. And so we are asking, different, to the extent that state courts, because that's kind of where I have my most influence with, to absolutely collect data on all of the fundamental measures, that they are fundamental to the objective of increasing access to justice. The supplemental measures either are secondary objectives that the program may have that are separate from access to justice, or oftentimes may reflect either just more difficult data elements to get. And so just recognizing the logistical difficulty that some jurisdictions may have in collecting the data. And so you wouldn't want to put that many eggs in that basket if you would ultimately be unsuccessful. But this is the idea that for those those fundamental measures, that everybody collects them, and therefore you can compare them across states.
Okay, great, thanks. Amos, and then Sharon.
Right, thank you for that. That was very interesting. Just quickly, you mentioned, I believe, that Washington State didn't have the infrastructure in place to allow you to do this type of evaluation. And I just was wondering if you could just explain that a little bit. Is it that they weren't doing data collection for these fundamental measures, or was there some other infrastructure that you would have wanted to see?
Well, they did not really do anything in terms of collecting baseline. And unfortunately, what we discovered, part of our evaluation plan was to basically take all of the LLT cases that had been filed in the superior courts in Washington State and compare them to a sample of similar cases filed by attorneys, as well as similar cases filed by self-represented litigants. So we could do that comparison. Unfortunately, in the case management system, the LLTs all were given a quote unquote bar number that they needed to use whenever they were filing a case on behalf of their clients. But that bar number was not being captured in the case management system. And so in order to identify the LLT represented cases in Washington State, we literally would have had to go to every single superior court and sit down with the paper files and read them to figure that out. And it was just a non-starter. So, and then we ran in, we tried to go to the LLTs and get, can you give us the list of at least your clients and the case number, and we'll backtrack it from there. But there were so many issues about whether or not they would give us all of their clients or just the clients that they were particularly, thought would give particularly good results to. And a number of them also objected because under the rules of professional conduct in Washington State, that was actually, they could not do that without client consent. And once the sunset provision came in, many of them said, I'm just not willing to do any collaboration in this because there's a target on my back. And I think that this will not end well for me. So that's where we were.
Thank you.
Darren.
Thank you so much for your all your thoughts on this and for all your work on this. I know that we have heard a lot of public comment from folks who have concerns about the increase of notario fraud. So that would be, fraud not necessarily within the system, but an increase of folks who are not getting licensed, who are bad actors. Where in this evaluation are you testing that? Is that just like through public trust? Or which of those quadrants looks at that?
So I didn't hear what type of fraud.
So, and let me just jump in. What Sharon mentioned, she used the term notario, which is notary.
Okay.
Often people from other countries where notaries play a different and a much broader role than they play in the United States. Basically the concern of if someone's going to hold themselves out as a paraprofessional and represent that they actually can do more than what they're allowed to do. Sharon, was that the thrust of your question?
Yes, thank you, Justice Petro.
Okay, yeah, I think there are, some of the measures and the measures that we actually published actually have some detailed suggested questions and things like that, including some questions for the client survey of, did you understand, did the person actually explain what it was that they were authorized to do? Did you understand, were they able to, explain that? So that some ways of sort of measuring the client's understanding of what the person was holding themselves out to be able to accomplish. So that would come in, I think, with some of the client satisfaction. The other piece of it would certainly be with the, with the outcome. If somebody is holding out that they can get a different, a better result, and then not delivering that better result because they're not qualified or competent to assist the client in that way, I think it would show up in that manner of disposition in the micro internal quadrant.
So I guess I should reframe it. So it wouldn't be the clients of these paraprofessionals. It would be the clients of the legal actors. Is that what you mean by clients?
Yes.
So folks who are using maybe the ambiguity of what the public thinks of paraprofessionals and are not getting licensed and are defrauding folks.
Okay. Yeah, actually, under those, logically, they wouldn't show up on this quadrant, except to the extent that possibly in that macro external of the legitimacy of the role, because people are confused about or have widespread perceptions that this is a fraudulent. So I think that's probably where the measure would take place. But the actual, because you're not measuring the impact of people who are not actually certified under your definition, wouldn't actually be somebody that you would be evaluating individually.
Thank you.
Okay, let's hear how this is playing out in Utah. Anna and Alex.
Sure, I'll go ahead and get us started. And Alex and I are going to be pretty quick. Our goal is to take 5 minutes or less. So you can let us know, hold us to that, wave your hands if we run past it. So I just want to make 2 points to get us started. And the points that I'm going to make are sort of meta and meant to just give you a little bit of a framework for thinking about how to approach evaluation of this program. So these 2 points are, number one, that there's a distinction that's meaningful and useful between research and program evaluation. The second point is that studying things is expensive, both in terms of financial investment, right, money, and human resources. And of course, there's a Venn diagram or a circle between those two things, depending on how you think about them. So Alex and I are a particular version of what it means to study things, right? So we're academics and we are interested in doing research. And so you could think of this, if you think of research and program evaluation as a Venn diagram, right? Research is about, we're interested in creating new knowledge, right, within our respective fields. And for us, that's a mix of law and political science. We're interested in understanding things about legal regulatory reform and paraprofessional licensing so that we can generalize that learning to other contexts, right? So we could learn things from what Utah is doing and have something to say about what that means for other states as they explore these issues, for example, right? And by contrast, program evaluation, which is sort of a subset of research, is about questions of, is this specific program working? The questions are the research is driven by looking at, here's a program goal, are we meeting that goal? And I think it's worth understanding that as we move forward, whether with other reg reform projects or paraprofessional licensing, that both of these things, sort of broader research and program evaluation, are important and can be a part of the conversation. So to give you a sense of what Alex and I are doing in Utah, we tend to do our research by talking to human beings about their experiences. We also count things sometimes, but mostly we talk to people and gather what we call qualitative data, right? So the kinds of things we're looking at in Utah include learning from licensed paralegal practitioners what they think about the program. Right? Are the requirements that Utah has a match for the services that they're trying to provide? What are they doing in their work? Who are they serving? Are they getting the right kind of support? We're also interested in talking to LPP clients about how they found their LPP, why they chose to go to an LPP instead of a lawyer, and what is their subjective perception of the quality of service. We're also interested in learning from broader stakeholders, right? So lawyers, judges, other stakeholders, what are their views about paraprofessionals? For example, what might make a lawyer more or less willing to collaborate with an LPP in their practice? What factors might lead a state Supreme Court or a bar association to support or oppose paraprofessional licensing? So these are some of the questions that we're exploring. So that's point one. Point two is money, cost, human resources, right? We want to know things about the world. We've got to spend money to do it. The more things we want to know, the more it might cost. And then there are questions about where that cost gets born, right? So that might be born internally, say, right, within the California bar, hiring internal staff to do research or hiring outside consultants. Or it might be external, as in our case in Utah, we have a small grant from my university that supports our work for a year. The courts are not, and the bar aren't having to spend any money to support us. And beyond that first year, we're going to need to seek additional funding sources to continue our work in Utah or to expand that work to other jurisdictions. And I will close and hand it over to Alex.
Thank you. So I suppose I have one additional point to make and one to reinforce. So in the course of standing up our research project or independent evaluation effort in Utah, we've observed some important tensions or challenges that we would like to raise at this critical moment that you all are in when you're thinking about the role evaluation is going to play in your paraprofessional program. Keeping in mind, I am sure you are already thinking about all of these things, but from our perspective, we think that they are quite important as well. So the major challenge I think that's going to inform the couple of things I will mention is defining the scope of your inquiry. And I know this sounds a little bit basic, and this is related, I think, to Paula's fundamental versus supplemental point, which is there are differences between the things we'd like to know and the things we need to know in order to understand what a paraprofessional program is accomplishing. And this is tied to a couple of points. One, how do we measure things? Two, what are we comparing the paraprofessional program to? And three, to one of Anna's points about resources, are we thinking about the burdens that we're placing on researchers and entities in our quest for data? So very, very briefly, when we're thinking about our list of need to knows, I think it's really important to think critically about how we turn those research questions into measurable objects, right? What do those measures look like? What are the paths to collecting those data? Are those paths already defined? Or do you need to find people in the universe who are going to chart the path to find those data? Two, what are we going to compare our paraprofessional program to? Paula also made this point earlier. Are we describing the paralegal or the paraprofessional program as its own object? Like, what does it look like today versus what does it look like in the future? Are we comparing the services to lawyers, to the status quo for self-represented litigants? Are we comparing across states? And how much does your evaluation program need to expand in order to answer that group of need to know questions that you have? Finally, and I think this is related to measurement challenges and how we use the data, is that we need to consider what resources are needed for a successful evaluation. Anna has made this point. I just want to reinforce it, that I think it's really critical to think of who in this evaluation process we are putting the burden of data collection on, right? If we're thinking about asking entities, asking paraprofessionals to report a lot of data to us, that is an immense burden on a group of people that has never been experienced at that level in the legal profession before, right? So thinking about that burden, both in terms of human and monetary resources, we think is pretty important. So thank you again for having us. Really appreciate it.
Thank you. Any comments or questions by the working group? If not, I don't see any hands up. I'd love, Linda, for you first to spend a few minutes. Oh, Carolyn, but maybe put the slide back, Linda, with some of the metrics that we've come up with, because I'd love to look at these and have members of the working group think about them as fundamental or supplemental. I think it's a really good construct. Carolyn?
Okay, just a number of just straight up statistical questions, because I haven't read too much about it, and it sounds like you're the boots on the ground with regard to Utah. Could you be more specific about the data that you've collected so far? How many licensees are there in Utah? How many clients have there been? How many have you interviewed?
Sure. So we're looking at numbers. We just had a class that came that I'm not sure they've been sworn in yet, but we're looking at the number of LPPs in Utah is under 20 people, right? It's between 15 and 20 right now. I'd have to email the person who runs the program at the bar to get the exact count, but we're talking about low numbers. We don't have service counts yet because we're not that far along in that data collection process. Did I cover all your questions, Carolyn?
Yes, yes, thank you.
So with what you've heard so far, and we have up on the screen, I think this is everything, at least again, that my notes and listening to the recordings reflect we've potentially come up with. What do working group members feel? This idea of fundamental versus supplemental, the idea of collecting the National Center for State Courts fundamental metrics so that at least we could commit to comparing our program performance against those in other states. Okay, good. Stephen and then Claudia.
Yeah, I'd just like to follow up on Carolyn's question. Do any of you have the stats for Arizona?
Arizona just gave their exam, their first exam. So I don't know what, Paula or Anna, do you happen to have that? I can ask.
But no, there's two, right? So Arizona has authorized a paraprofessional program that looks like the kind of thing that California is contemplating and that Utah has done in the LPP space. There's also another existing pilot program called the Licensed Legal Advocate Pilot that's being run through the University of Arizona's Innovation for Justice Lab. And that's specifically in the context of domestic violence cases. And it's essentially an upskilling program that takes existing domestic violence advocates and gives them a limited couple weeks long legal training. And then they're doing a really intensive evaluation. So there's actually two pieces to be watching coming out of Arizona, and we don't have any reporting on that. I don't know, Alex or Paula, anything I'm missing there?
I have not heard anything yet at this point. I'm
Thank
hoping to
you.
hear more. There's actually going to be a convening in the beginning of September with the Conference of Chief Justices and the Conference of State Court Administrators for the Western region. And I know that there's going to be reports on Arizona at that point.
Claudia.
Hello. Thank you. So thank you for the presentations. They were very useful. I very much liked I believe in the first one, when we're talking about how to recruit prospective paraprofessionals, right? How to get them certified, the investment cost. The part that I really thought was useful for us, which I don't think we've covered much of, is that support, the support that they may need to stay in business. I know in the slide that we have up right now, we're talking about the program viability, them having stable and sufficient income, right? So I see that we care about them staying in the business, financially speaking, that it's worth it in terms of the investment and the gain. But I'm wondering what we can do just to integrate that support for them so that it can be attached to the metrics for potential seeing the outcomes, right? So that we see that it matters that they are receiving the support in terms of having higher outcome, in terms of that access to justice, right? Access to justice also is impacted by how well these folks, these paraprofessionals, will be able to be part of the community. And I think this is connected to the questions that then we're asking later, right? Is how do we compare the success of the program? Yes, compare today to the future, or are we comparing the success of the program versus the other lawyers, folks, or to other states? I think these are really great questions to ask and to keep in mind. So thank you for bringing these up.
Amos and then Sharon.
Thank you. Yeah, so I was involved somewhat in trying to implement the evaluation of the Sargent Shriver Civil Counsel Act, which is another example we have in California of providing legal services, in that case, a lawyer, in certain circumstances. And a lot of what I've heard today rings true. I think there was a lot of difficulty identifying or defining what constitutes successful outcomes, especially in these types of cases like eviction cases, where it might not be a win in the case, but it might be no judgment or extended time or not needing to pay the full amount of past rent due, and all sorts of different outcomes. And it really might depend on the case type. So interested to just think through who is defining that, and if it makes sense to have an independent evaluation. In the Sargent Shriver Civil Counsel Act, it was part of the statute and the funding that there was a separate RFP and an independent evaluation, which I think was very, very useful. I don't know we haven't yet talked about evaluation here. I think this is our first time. So interested in people's thoughts of both defining success, or here on the screen, results, and sort of if it should be, or if we should be contemplating an independent evaluation.
Paula, do you have any thoughts on that? Because it looks like in the NCSC framework, there is a contemplation of looking at case outcomes.
Mhm. Yeah, and this has to do, and I definitely appreciate Anna and Alex's comments about, you know, how resource intensive it is to collect data. I'm used to working with court data, you know, just information that's extracted directly from the case management system. And that's probably the easiest place to get it, but often the granularity of case outcomes is pretty broad. I've certainly been in some courts that are pretty good about making a distinction between a settlement versus just having something that says it was dismissed with prejudice. And so was that a settlement, or was it, you know, what does that mean really, but not necessarily telling you much about it. Same thing with it's a judgment, but was a judgment for whom? Was it a default judgment? Was it a summary judgment, or was it an adjudicated decision? So depending upon, you know, what is actually there, may make you know, a bit of a difference, as opposed to if you are really looking for the, you know, did it favor? That may actually involve data collection and of having to go in and actually read court documents, or find some other mechanism for getting that information about, you know, what were the terms of the settlement, to be able to actually make determinations about the favorability. So I'm very sympathetic to Anna and Alex's thought about just how resource intensive that is. And so part of, I think, as you're thinking about these measures, part of it will involve just looking at, you know, your baseline and what is the infrastructure that already exists in California, in terms of the quality of data that are collected by courts, or if there are other administrative agencies that would potentially be involved. What do those systems look like, and how easy is it to get, or, you know, to get those data for evaluation purposes?
I agree with everything Paula just said, and I'm going to tee up something for Alex to see if she will jump on this. So the tee up is, we could know from court data that X percentage of lawyer cases resolved in Y way, and that A percentage of paraprofessional cases resolved in B way, whatever the difference in the counting is. But so that's great if we can know those things. And as Paul is saying, even that can be really challenging. But there's then a next level question, which is, why are we seeing the similarities or differences in what we're seeing? And I'm wondering if Alex wants to riff on that at all.
I could, but I would keep us too long because this kind of stuff gets me really excited. But some of the challenges, right, in the why are these additional details about what is actually going on in a hearing, for example. And this is something that we are exploring in some of our other work now. But again, it is a data challenge to extract that data from courts, and it is a data analysis challenge to know how to make sense of that information. So part of this is a quantitative response, but then the other part is the deeply challenging qualitative work that is associated with understanding why outcomes look the way that they do. And those are really important questions to noodle upon. And I know that we would be very happy to noodle with you if those are things that you are interested in. And I will say noodle one more time because it's a great word for thinking. Okay, thanks.
I don't know, Amos, if anyone addressed your question of an independent evaluation, and did you mean that as opposed to the state bar doing the evaluation?
Yeah, so in the Schreiber Civil Counsel Act, there was actually a separate RFP for, I think, social scientists to come in and evaluate, and that's what happened. That was by the court, so the courts didn't evaluate it themselves. It sounds like the National Center is looking at doing evaluations of these programs. Again, I assume that's instead of or in place of or in addition to bar associations or courts or others. And obviously we've already seen academics do some evaluations. So yeah, I would say independent, but paid for by either the state or the bar or however that would happen.
Okay. Any other hands up? I don't see any. I'm scrolling through. And I'm conscious of the time. I think this.
There are some other hands up.
Oh, okay. Go ahead and call them, Linda. I don't see them.
Sharon was next.
Thank you. So I too am an outcomes geek. So I am doing a lot of noodling right now. And I am wondering if we want to, I guess when we are looking at outcomes, in addition to comparing outcomes to attorney cases, do we also want to have a control group of self-represented folks to compare paraprofessional outcomes to self-represented folks? That's the first part of my question. The second part of my question is when we are trying to gauge consumer satisfaction with the services that they got from paraprofessionals and outcomes, what are best practices that don't overly intrude or don't, like I'm concerned about privacy concerns, and do consumers need to opt in for us to get that kind of data?
So I'll take a little bit of a stab at that. I think when you're doing that client, if you have contact information, for example, in court files, that you can reach out and actually ask for client surveys. You should probably have it as a voluntary, confidential. I know with the National Center, we take it through an institutional review board approval because of the confidentiality issues. You do have concerns about response rates. That would certainly affect the reliability of your results. But you can, I think, address some of the privacy issues in that way.
So one thing that I'll add to what Paula has said, and I think that it's a really smart idea to think about the self-represented litigant group as a comparison. But one of the issues there is the way that they get to court as a self-represented litigant. And there's a lot of stuff that one would need to control for to assure that the routes that people are taking to court are your doing and not the doing of something in that person's environment. So it is really exciting to think about research designs that look like that, but they are super challenging and sort of like ethically tangly to pull off. So that's just something to keep in mind.
Yeah. The other is the problem with the, particularly with the self-represented litigants. For a lot of the cases that at least have been talked about, family law, consumer law, landlord-tenant, so many of the self-represented litigants, essentially never actually make any appearance in court. It's just a default judgment, and we're talking, in some places upwards of 70%. And so you don't have an opportunity to survey those folks. If you did, then maybe they would actually be engaged in their own case. As opposed to the ones where presumably they're coming into court with this paraprofessional and at least making some sort of an appearance that you can reach out and do that. And so you do have this self-selection problem of who exactly are you measuring? The same thing with trying to measure against attorneys. I don't remember the last time that we ever had any type of, certainly at the National Center, had any type of success actually surveying clients of attorneys or even getting to them to ask about their satisfaction with the legal services that they got from attorneys. And so the baseline there is extraordinarily difficult.
Isn't the default rate, though, a data point in of itself?
It is, and I think that's the one with manner of disposition of just looking with, in this group of cases with self-represented litigants, 56% were, had a default judgment, and with the paraprofessional, it was 10%, or or whatever the number that that you are hopefully going for. But presumptively, optimistically, much lower than what you would see with self-represented litigants.
Kim?
Thank you for the presentation. Now I'm like thinking of a ton of million things all at once. But just narrowing it down a little bit, just thinking, first of all, like for us, for California, there's so many entities outside that we'd have to ask questions of potentially and have that ready before you get going, like the schools that are doing the training, the courts, making sure they're providing information. For us, we have an employment development department that could give you information on salaries and what these individuals make. I'm just questioning how much of that did you have prepared before you really started this, like before the program rolled out? And then another question on that customer satisfaction, because that can really be, it's a difference of opinion, right? Depending on what you're asking the individual. And how do you kind of get the information to where it's able to be relied upon when customer satisfaction could be, I wanted, the win, I didn't get the win, but by having this individual rather than being pro per, I did get one step closer. So how do you kind of build all of that into your evaluation?
You hire a really competent program evaluator who can suss that out is the quick answer. And I don't mean to be flip about it, but those are really difficult problems to suss out.
Do you want to take the first part of Kim's question, Paula or Anna? I think basically like how much did you have in place? So Kim, I think neither Paula or Anna has actually set up one of these programs. They're evaluating them.
Yeah.
So I'm not sure how your question about how much do you have in place from the get-go, I'm not sure how it applies exactly.
So I will say Tom Clark, who was my co-author on the other one, he and Becky Sandiford did a process evaluation of the Washington LLT program that was published in 2017. That did spend a lot of time looking at the like who was actually offering the classes and what were the challenges associated with developing the curriculum for LLTs, and what obstacles did they have in recruiting faculty and institutions to support this type of training. So I think there are opportunities. This was not part of what we were looking at for when we anticipated doing the Washington, was more of an outcome-based as opposed to the process. But I do think a process evaluation would actually be a useful part of your, of your evaluation process, for the California Paraprofessional Program.
And I think a related point to what Paula has just said is sometimes you don't know what the questions are until you talk to a bunch of people about what you're interested in. So I think one thing that I really love about Anna and my project is that as you're interviewing people and sort of finding out what happened, you can extract themes from what people are saying and use those data points to sort of build those larger N surveys or those larger sort of like distributed sort of like survey or focus group types of projects. But I think some of these questions we recognize we don't know what they are, but there are people out there that do know what they are. And it's important to talk to them.
Thank you.
Julia?
Yeah, I had a question for Paula. You said that there had not been any process in place on how to track things and you literally had to go to the courts. So in California, we have what is called a civil case cover sheet. Did they have those kind of things and that's what you looked at to determine whether or not a paraprofessional had filed the court document? Or what is it that you looked at to determine that?
Well, we were looking from the data that was entered on the case management system, because there is a space for to indicate whether or not a litigant is self-represented or is represented by an attorney. And if it's represented by an attorney, they put in the bar number, the Washington State bar number. But for the triple LTs, they were not actually entering the triple LT bar number. So we had no way of, if they gave us a data dump, of identifying which cases were triple LT cases. They were just kind of in there, you know, probably marked as like self-represented litigant because they were not actually represented by an attorney. They were represented by a triple LT. There was a civil case cover sheet, and they statewide, they used the Odyssey system, but it was not possible to, they were not digitized in a way that you would have been able to easily scrape the images to identify the triple LT number on the civil case cover sheet. So we were sort of in the same thing that it literally would have meant going to the court and sitting down with the paper files and reading the civil case cover sheet and saying, okay, I'm looking for these. At this point, it was like 44 bar numbers that were literally could have been filed because they, Oregon does not, or Washington State does not actually have venue requirements. So you can live anywhere in the state of Washington and file for divorce in any other county. And in fact, many of them do, because there are some counties that are particularly good because they get their local filing fees. And so there's an incentive to make it real easy to file there.
So are you thinking it would be advisable that if we are at least trying to come up with a method to collect that information, that we could maybe go to our judicial counsel and ask them to alter that cover sheet so that at least we know that one thing, for example, that this is a case filed by a paralegal versus this is a case filed by an attorney?
Yes, yes, definitely. Yes.
Okay.
Please. Yes.
Okay. Linda, are there any other hands up?
No, there aren't.
Okay. So given the time, I think we need to move on. We're going to bring this back in August, and my intention is to have more of a proposal for the group to consider, rather than setting up yet another subcommittee on evaluation. But I'll just leave it at that. I think if folks feel strongly that we need another subcommittee, maybe we can hear that later at the end of the meeting when we talk about next steps. And with that, Justice Petru, if you want to turn to public comment, we can thank our guests. Let them
Yeah,
know.
exactly. I'd first like to thank our guests, especially given where you are and that it's after 5 o'clock there. So thank you very, very much. It's very useful to us, and don't be surprised if we come bugging you with some additional questions, okay? Thank you.
Absolutely delighted to help.
Thank you very much.
Thank you.
Bye.
And if folks who are attending could please raise their hands if they wish to speak, and so I can get a sense for how much time we'll set aside. And Linda, I see that Nicole Robinson is listed as talking permitted.
She's on the working group.
Right, but that's why I'm wondering, why is she in the
Because
attendee?
she's joined by phone and so wasn't able to join as a panelist, and I'm not able to promote her since she's joined by phone. So this is the only
Okay, I
way
didn't
can
realize
bring
that
her
if
in.
you joined by phone, you couldn't be promoted to a panelist. Okay, understood. Hold on one second. Okay, why don't we do 2 minutes each and we can get started whenever you're ready to start, Linda.
Okay. Sorry, just 1 minute. Okay. Got Charlie Gillig.
Hey, good afternoon. I was actually going to talk about evaluations. This is perfect. I'm vice president at Neighborhood Legal Services, legal aid organization. I do want to stress that I think this is a really important conversation, and I think a standalone meeting to discuss would be relevant, as it seems like a lot of members have outstanding questions, and I think that we should dive deeper into it. I would say that it's important that we don't rely on only court data for this moving forward and do build some sort of independent case management system. I think the California Civil Court Data Collection System, JBSIS, is not going to be able to collect the sort of granular data that will be necessary to evaluate the program. And as you all know, California is not a unified case management system like Utah, so it's going to result in a lot of fragmented data. Although I do agree with that comment about identifying cases as being represented by a paraprofessional or whatever the new terminology is. In terms of burden on paraprofessional, I understand that. Certainly as a legal aid organization, I understand that. But I think that this data, again, especially for a new program, is incredibly important. And to Amos's point about Shriver was, and I've worked on those reports, overly burdensome in a lot of ways and had an enormous amount of data they were collected. I think there's a balance here. And I would, again, also agree with the idea of bringing in a third-party evaluator to think those through. But I think having that separate system where people report into is a better way that we can choose the fields. Maybe
30 seconds remaining.
In terms of the two reports, a few data points that I think we should really think about adding. I like the thought of trying to monitor the quality in relation to an attorney. Other points, I think income should be collected. Fees are really important to understand some of the sort of fraudulent behavior that may be going on. It's listed as supplementary, but I think it's essential. I think level of service, something that we collect as legal aid or.
Okay, that's your time. Thank you.
Thank you.
Angela Grijalva.
Good afternoon. This is Angela Grijalva. Thank you so much for this opportunity to speak and your hard work. So one of the things I wanted to contribute is a growing concern amongst the LDA community of specifically Fariba's repeated comments about eliminating our profession. And then about, I think today, when the presenter was discussing conflicts of interest within the program being under the state bar, I think that also highlights the concern why maybe we should think about moving this paraprofessional program outside of the state bar and actually going to look to expand and bolster the LDA profession instead of reinventing the wheel, but an expansion of what already exists. And so that's my input. And I really, really hope that y'all pay attention to this, because I don't think Fariba's alone in that sentiment. And it really did send shock waves throughout our profession. Thank you.
Okay. Michael Barth.
Yes, thank you. Good afternoon. My name is Michael Barth, staff attorney with Public Counsel. Public Counsel does remain wholly opposed to the creation of a for-profit industry of paraprofessionals. We maintain that the subcommittees have not adequately consulted with experts in the subject matter field, and even when field experts have appeared, their experience with these have not always been heeded. This is especially true in the consumer area, where allowing paraprofessionals will not help debtors access to the court and may prevent affirmative federal claims being brought in their cases. We do have some feedback to pivot to regarding the rules of professional conduct. First, on disclosures. In Rule 1.4.2 and 1.4.3, we believe the disclosure that there may be free resources that are available to low-income individuals is an important one, but it is also necessary to amend that to state that the professional must provide accurate contact information for those specific legal services in the community. We also believe it must be made crystal clear that paraprofessionals are not able to litigate in court without needing to represent them in federal court. The client would have to effectively waive federal claims. This is touched on in 1.4.2, but we believe it needs to be more specific, as is the rule merely states that there are some things that they cannot do because they are not attorneys, but it's not obligate further specificity on that point. And then on fee caps and regulations.
30 seconds remaining.
Thank you. Under the proposed rules, there is no fee structure of any kind for different substantive topics, it appears, nor is there a sliding scale fee structure that caps a paraprofessional's hourly fee based on client income. At an absolute minimum, paraprofessionals should be required to report the fees charged for different services in order to evaluate the effectiveness of the program. Thank you.
Okay. Leonard Sansanowitz.
Good afternoon. Thank you very much. I'm a plaintiff side employment attorney based in Los Angeles. Regarding the proposed rules of professional conduct for paraprofessionals, specifically the rules governing conflicts of interest, the rules are modeled after the RPC for attorneys, and the inherent flaw in this model that I see is that it fails to anticipate a scenario in which an entity that employs paraprofessionals on side A of a dispute is owned by the same corporate parent that owns another entity providing paraprofessionals on side B of the dispute. And in such a situation, neither paraprofessional individually would have a conflict, yet the parent company could pressure both. Why is that important? Because this would potentially depress settlement amounts across the board for all disputes within their practice area. And that would make it more challenging than it already is to obtain fair settlements for the most needy. There already exists an inherent bias that settlement values or verdicts should be tethered to how much economic loss a plaintiff has suffered. And this bias favors the rich and delegitimizes the pain and suffering of the poor. So just because one earns less does not mean that one's suffering is of a lesser value. In fact, I would argue that an indigent person suffers more, much more than a wealthy person if they lose their job or their benefits or their housing, and should be awarded even more than the wealthier litigant. So I would urge this committee to expand the idea of what it means to have a conflict of interest. Also, I'm troubled by the use
6
of
seconds remaining.
Thank you. I'm troubled by the use of phrases like the court user market or consumers. The people who are supposed to be being served by this program are the most needy, and the use of that type of language seems to suggest that the true motives behind the program are not to provide access to justice for the most underserved, but rather to increase the greatest number of consumers of legal services in the court user market for businesses to exploit in the sandbox. Thank you.
Scott.
I will take a wild guess and assume that means Scott Bernstein. That's me. From
The only name up here that shows is Scott.
Okay, that's good. That eliminates the ambiguity. Thank you. I would like to speak about the 49% limitation on paralegal entity ownership of law firms. To people who haven't practiced in the area of corporate and entity control, that might sound like a meaningful protection. It is not. Perhaps in a situation where you had a 51% single owner interest that was a law firm, the law firm would prevail in a disagreement. But in a more likely scenario where the rest of the ownership, the rest of the entity was widely held, say 17 3%ers, the probability of the paralegal firm with a 49% of the vote being defeated is very low. Even if it had only a 10% chance of persuading any of the attorney 3% owners to side with it, the probability of it losing all 17 out of 17 would be less than 1 in 6. In other words, it would have a greater than 83% chance of prevailing on the vote. So that kind of limitation, while it might look impressive to people not familiar with corporate and entity control, is really the kind of thing that should provoke laughter on the part of a 49% entity that wants to have its way, perhaps in violation of or pushing the envelope on ethics rules or public protection rules. That is
30 seconds remaining.
That is just one of my many concerns about this proposal. Thank you for allowing me to speak.
Lee Farron.
Good afternoon. Thank you for the opportunity. I just have a couple brief comments. First, I'd like to thank the Housing Subcommittee because my office did submit some suggestions to that committee and they were considered, and I appreciate the exchange and the thoughtfulness. Second, I want to speak a little bit on public education and marketing. I'm not entirely clear on whether that conversation will focus on the public education and marketing that comes out of the state bar, or if it'll come from the paraprofessionals themselves, but I suppose my comments could be relevant either way. The public-facing materials are particularly important in terms of not only educating the community, the public about what the program is, but also ensuring that their expectations are managed. One of the things that I've mentioned in the past is that, as a practicing lawyer, one of the biggest sources of conflict with clients is when expectations are not properly managed from the outset. So being clear in advertisements and marketing materials that there's, a limited type of assistance, whether or not there will be a charge for services. I'm assuming there would be, is because it's a for-profit program, that no outcomes can be guaranteed. One of the biggest things that we see with fraudulent and misrepresentation advertisements, and the way that our clients are often
30 seconds remaining.
Thank you. Are taken in is by being told that an outcome can be particularly guaranteed. I think it's particularly also important to note, as I have in the past, that whatever restrictions or protections are put in place need to be considered in multiple languages besides English, because there is a strong likelihood that folks who do not speak English as their first language will be utilizing these types of services. Thank you so much.
Amy Kirby.
Hi, good afternoon. Thank you for hearing me out. I had some initial questions. This is my first time attending one of these meetings. I'm a plaintiff's attorney that works in both Northern California and Southern California. I'm also licensed in California, besides California, Nevada, Arizona, Texas, and Georgia. And my questions really are, with the problems that we've seen in the state bar so far, with the state bar overseeing just attorneys, what kind of mechanisms do we have in place to protect the public? Is there going to be a 1-800 line? Is there going to be CLE requirements? Is there going to be somebody overseeing these paraprofessionals that's going to be responsible? And who's going to provide the insurance for these paraprofessionals? These are kind of my concerns as an operating system. What would occur if we put this into place? And how do we protect the people that we're trying to serve? Because we're not doing it with the attorneys currently. It was all over the LA Times recently what happened with one of the plaintiff's attorneys. So that's my questions. I can forfeit my time, whoever's next.
Jennifer Ostertag.
Good afternoon. My name is Jennifer Ostertag. I'm a plaintiff in Los Angeles, and I'm representing plaintiff in employment cases. Early on in my career, I was in-house counsel. I just wanted to bring up my concerns about the proposed rules of professional conduct. The first one is Rule 1.5.1 regarding fee sharing. I have serious concerns that fee sharing should not be allowed for the program. First, they are not necessary to start the program, and fee sharing is essentially a backdoor way for cappers and others to take advantage of people who are supposed to be held for this program. Like Ms. Kirby mentioned earlier, the state bar has limited resources, and it should not be wasting those resources policing fee sharing violations, which are gonna happen. The second rule that I know is being considered by this group is Rule 5.4 regarding ownerships in law firms. Regardless of while it may sound really good to have a minority ownership in law firms, I think as Mr. Scott Burstein explained earlier, the reality is when you have somebody who can possibly have 49% ownership in a law firm, they will be influencing—
30 seconds remaining.
Thank you. They will be influencing the policies of that firm, compensation, hiring and firing of employees. And lawyers have to be able to fulfill their legal and ethical obligation to their client without any outside interference or even the appearance of such conflict. So I think to start the program, there need to be a ban on any type of fee sharing or ownerships outside with lawyers or any non-paraprofessionals. Thank you. Thank you.
Minyoung Lee.
Thank you. Hello, my name is Minyoung Lee, and I'm a family law attorney from Neighborhood Legal Services of Los Angeles County and work with survivors of domestic violence and sexual assault, providing free legal services. I have, to the best of my ability, tried to follow along with the Family Law Subcommittee group as they work through the process to provide the recommendations to the larger working group. And I know that it has not been a small feat, and I thank them for the enormous amount of time and energy that has gone into this. I was heartened by the last meeting that occurred where Leslie Heimoff from Children's Law Center and Amanda Kennedy from Law Foundation of Silicon Valley were able to provide their expertise and perspective, really at the very last hour when the subcommittee group had already been ready to provide their recommendations regarding juvenile dependency. This last meeting, their input was so compelling that it did ultimately shift the recommendations of the subcommittee group, such that now the recommendation is that juvenile dependency as a whole be excluded from the paraprofessional program. I believe that this type of specialized knowledge and expertise could have benefited many areas, other areas that the Family Law Subcommittee group has decided on. More than a select few attorneys coming on to do a presentation, but that there really would have been a think tank of those who practice in those areas to come together and be involved in these recommendations from start to finish. Having said that, to conclude my comment, I, as an attorney who have been practicing in juvenile dependency and family law for 14 years now, find the overall list of recommendations for family law to be quite difficult to understand. There are lists that need to be referred to, resolutions that may
30 seconds remaining.
That must be referenced to hopefully understand the other list, and within those exceptions, what paraprofessionals are then allowed to do or not to do. So I would ask that this working group that in the area of family law, that there would not be any court representation. However, if it does contemplate that some form of representation is needed, that adopt the common denominator and allow for paraprofessionals to answer procedural questions from the court and nothing more. This is a new program to create all sorts of pockets, it's hard to decipher. Thank you so much.
And the next one is LAFLA SFWG.
Hi, sorry. Yes, this is Juliana Lee from the Legal Aid Foundation of Los Angeles. Thank you so much. I appreciate the Family Law Subcommittee's work on its recommendations. I've reviewed them and I'm concerned about this working group's recommendation to allow in-court representation by paraprofessionals, particularly in the family law and violence prevention contexts. In its current form, it goes against advancing access to justice by creating a second-tier system of justice. It creates a new and lower baseline for professional competence for low and modest income litigants. So far, the focus has been on comparisons between this baseline and going without representation, but the baseline will have corrosive effects in many other instances too. Indeed, this baseline could be damaging to under-resourced litigants in innumerable ways at innumerable stages of their proceedings. So one, judges frequently give the minimum adequate award for attorney's fees, if even given at all, which if key to paraprofessional rates would mean the less resource litigant would get the less credentialed representative. What also is the recourse for a litigant who is represented in court by a paraprofessional to seek reconsideration or an appeal? Opposing parties will point to the training and qualifications, the stamp of approval from the state bar as to why the paraprofessional assistance is substantively no different from that of an attorney. And what of litigants who request a continuance to seek assistance of counsel when they have a paraprofessional who is inadequate or providing poor service? There remains the fact that many less resourced litigants will still be unable to hire a lawyer or a paraprofessional. But for the courts, the deficit will change from the chasm between attorney representation and self-representation to the more modest
30 seconds remaining.
Thank you. And going it alone. Lowering the baseline of minimally acceptable professional services will predictably reduce the court's perception of the deficit that self-represented litigants face. I understand this program has significant potential to create conveniences, but we are here to improve access to justice, which must include a focus on advocating for and enforcing the legal rights of those who are disadvantaged for a myriad of social and economic reasons. The idiom that something is better than nothing has been evoked several times, and that can't be the mantra by which this group operates. Thank you very much.
And there are no other requests to speak.
Let me just scan the attendees list again. Okay, I've scanned through all of them. I don't see any hands raised either. So Leah, I think we're turning to regulatory, is that correct?
That's right.
Okay, and do we have, Brady, are you in attendance?
Well, I think we're going to be hearing from Amos.
Yeah, and Greg, but I just want to make sure that people are back. So if you don't mind putting your video on, just so I can see that folks are here, and then if you want to take your video off, okay. I just want to make sure we're all being part of this conversation. And I know that Judge Yu is trying to get on, just having some logistical issues. Okay. Greg, are we starting with you?
Sure. We could start with me. I can just give an overview of the regulation subcommittee's approach to presenting the rules today. We have, and this is a method that the Rules Revision Commission followed as they started to funnel down and identify key issues surrounding certain rules where we're receiving public comment and whatnot, which is to, rather than trying to do individual votes on all 71, 72 rules, to have a consensus agenda item for vote. And so the group, I think, had been provided notice as to a copy of the revisions to the rules of professional conduct adopted by the regulation subcommittee, as well as a slate of the rules that would be placed on the consensus agenda item, and offering everyone an opportunity to identify any rule that they would like to take off of that consensus agenda and ask for individual debate and vote on rules. I don't know. I know that Steve Fleshman had asked that rule 1.17 be taken off of the consensus agenda. I'm not sure, Linda, if we received a request from any other working group members.
We did not receive any such requests in advance of the meeting other than the one from Stephen Fleischman, but I did indicate to people that if they wanted to make that request during the meeting, they were welcome to do so as well.
Okay. Well,
it looks like Carolyn does have her hand up. So.
Okay.
Quick question. Do we have a quorum here?
Yes, we do.
Okay. Yeah, is it time to discuss those things? Because I don't think it's been clear on any of those points. I have not had time to attend more than one of the regulation meetings, which I really was intending to do so, but with a job, found it really hard to do that. And I'm an object. This is so hard. ATILS 1 took months and months to discuss most of these. And so to say, okay, everybody, we're going to just have an up-down vote on 71 rules, I don't understand that at all. I just don't. And I know the committee has been very well-meaning in this. Amos and Fariba, both of you I know have worked super hard. But I guess the final rules were only put together like on July 10th. I don't know that I understood that the final rules were really final until last Thursday or Friday. So, it's 2:30. We have spent, an hour and a half talking about something that I didn't even know was on the agenda, evaluation of the program, which could have waited until the very end. So we're going to talk about 71 rules of professional conduct that modify at least a dozen statutes. We're going to talk about that, thumbs up, thumbs down, and have that presented to the state bar on August 31st with no public comment. And I think one of the committee members suggested in the last meeting that I did hear that they absolutely are aware that many of these are controversial. I can't fathom that concept whatsoever. We've heard from, 4 legal service providers that they're absolutely opposed to having this stuff be in court. I think it's really unfortunate that we're not going to give anybody more than 3 weeks or even 4 days to go through all of these when it took ATILS 1 months to go through 5.4.
So Carolyn, I completely hear your concerns. I just want to put a little bit of context on here, which is we aren't presenting anything to the state bar on August 31st. In fact, we're not done with our meetings until sometime in September, and it would have to be thereafter. Leah, do we have a presentation date?
I would be the September board meeting, which is usually the third or fourth week of September. I don't have the date, but I can get that.
Okay, and I'm hoping that as part of the review today, or as part of having, it's not that a brand new set of things were sent out. You're absolutely correct that the regulation subcommittee, has been meeting every Thursday, and I certainly don't expect you or anyone else to be able to, rejigger their work schedules to be able to attend that. I don't quite know how the people on the regulation committee are doing it. I will just say, but it's not that there were a whole new batch of things sent out last week. This has been an iterative process, and people have been working on this moving forward, and hopefully we can get some insight into what changes have been made since the last go round. But I hear your concerns. We did have to take the last subject first because of having people on the East Coast who couldn't stay later. I would like to move substantively into this and just see where we are, but especially, as you noted, given our limited time, I'd like to let the folks on the committee start the process.
Well, with all due respect, Your Honor, aren't we going to discuss family and housing also? Is that going to be put off? And then, so we're going to do regulation now and then family and housing in August?
We're going to see where we are after the regulation committee discussion today, and hopefully then move into family and housing. But I can't swear exactly what is getting done today.
Okay, well, I'm going to make a motion to table regulation until the next meeting. I think it's important to get all these subject matters together so we understand. When you do 5.4 and you do the advertising, how do we know? How do we know? We just heard that juvenile dependency is out. How do we know that's going to impact anybody's views on 5.4 and advertising and 1.1 for the conflicts of interest? It's impossible. It's absolutely impossible to know what to do with those controversial rules until we know what family law is going to look like. Now, I moved to table the regulation, any vote on regulation until at least the next August meeting. It just really needs to be vetted fully by us.
Well, the floor is open, including to be, to hear a response to that from anyone on the regulations committee, to if there's a second. I mean, this is your group for you to speak up.
I'm concerned that we're not going to have enough time to fully discuss regulation today, and that we're going to give it short shrift. And I think it's just really important that we give it enough time.
Amos and had his hand up, Julia.
Well, I just wanted to clarify in case it's helpful. I do think that the regulation subcommittee and staff has done a lot of work. So I don't want to undermine that in any way, but we were not doing the same thing as the rules revision process. We were not coming up with new rules of professional conduct. We were looking at the existing rules of professional conduct that were recently approved by the Supreme Court and considering if they were appropriate or needed to be changed for paraprofessionals. And we are not including in the group vote anything that we did identify as potentially controversial. So we have tried to identify that. There's not disagreement among the regulations subcommittee. We have a joint proposal for everything. But we did try to identify so that we could separate out discussion and comment and discussion about anything that we did identify as controversial, either through public comment or prior working group meetings. So, and that is a smaller set. So the idea is for the rules that are basically tracking the attorney rules with minor changes, such as replacing attorney or lawyer with paraprofessional or whatever the name will be, and some minor changes related to cross-referencing statutes that don't apply. And that is all in the summary chart that has been provided. So if there are any other rules that raise particular concern, I think now would be the time to identify those for us so that we could have separate discussions. But otherwise, the idea is we're not doing a full new rules revision. We are looking at the existing rules and as a base.
And I'm going to ask that we not have you know, and Amos, if there's more you wanted to say, but I just wanted to jump in to say, I don't want to start a half-hour process of going back and forth debating whether we should be discussing the rules. We're going to start the discussion today unless there's a second and a vote to put it off. And we're going to see how it goes. If it doesn't go well, it doesn't go well. If we feel like we need more time, that's where we're going to be, but we need to start the discussion. Linda, I just want you to know that Judge Yu is now online, so you can note that for your minutes, please. And I believe we have her until 4, until her next commitment. And Julia, you have had your hand up, so if I could please hear from you before we jump in.
I was going to ask the question of Amos exactly what he said about, are there any controversial rules? Is there anything that caused a great deal of a problem that is in where he's proposing today that could be pointed out? And, you know, that is what I was going to be asking for. Is there some controversial rule that we should know about that is inside all of this that would help us understand what the group struggled with?
Yes, and if you look at the chart of rules, we separated those out for an individual vote. So nothing that's we believe is controversial is included in the proposed group vote, and we will be separately discussing those that we are setting up for individual votes.
Right. And then Carolyn, there was Carolyn did make a motion. And so we need to know whether there's a second to postpone, today's discussion.
I just want to reply to what Amos said really quickly. First of all, that's the first time I understood what that blue section is, you know, and the difference between a group vote and an individual vote. And I still don't understand what a group vote means. Is that up or down every single box in here that isn't blue? And then I can see dozens, and I hate to say this, dozens of rules that are controversial and may be controversial. And,
right, and you can ask to pull out specific ones as maybe.
I think, Your Honor, that's with all due respect of you and the other, it's dozens. And I don't understand why we can't, well, I guess we can talk today. My motion is we table the votes. So I'm happy that, I think that's my motion right there. And I just would point out to people, in response to Julie's point, there are dozens of rules in here that are controversial. And I think it's unfair to say when the committee picks out a couple. I just don't know why we can't really get an idea from our public, from the public. And even I don't, have a time to take a poll of people in July when many people are on vacation of the things here that were taken months by ATEL 1 to direct us to study.
So there's a motion to not vote on anything today in regards to these rules. Is there a second for that motion? All right, I'm not seeing a second, so we're not going to vote on that. I'm going to ask now, it's 2:44, that we start with the actual discussion. And
Greg and Linda, can you put the PowerPoint up?
And I think what might be helpful is to begin the discussion with the 9 rules. I get 10 rules now that Steve has identified a 10th rule that may be controversial, and we could, move through that discussion, because I think there's agreement among those regulation subcommittee, while they have a consensus amongst themselves as to a recommendation for each of these rules, that it may engender some split votes among the working group. We'll begin with rules 1.4.2, 1.4.3, and then also 1.5.2. We grouped these together. We've started a conversation about this last time. These rules are grouped together because they're thought, I think, by the regulation subcommittee as being interlinked as a public protection set of measures to make clients and potential clients aware of certain aspects of the program, the limited licensure of paraprofessionals, and to obligate the paraprofessionals, ethically obligate them to make certain disclosures and obtain informed consent, as well as to enter into a written agreement for representation and prescribe components of that agreement as well. And the notice to consumer is intended to be a document and a set of just oral disclosures as well as written disclosures that are provided to prospective clients almost immediately upon prior to a consultation. So the client is aware that of certain aspects of the paraprofessional's license, including the fact that they're not a lawyer. And we'll go through that in a bit more detail. The informed consent, that is a defined term under Rule 1.0.1. And the informed consent requires the paraprofessional to obtain information from the client to know their particular situation, what legal issue they're coming with, to the paraprofessional with, what their needs are, and other aspects, facts and circumstances, so they can make certain disclosures to them and obtain their informed consent to proceed with representation. The written agreement is an agreement that really solidifies the aspects of the representation that comprise the written contract between the prospective client and the paraprofessional. So that's why we are grouping these together. Perhaps we should bring up the rule itself. And Amos, do you want to talk about Rule 1.4.2? One other thing I'll say about Rule 1.4.2. We do have a lawyer version of this rule, and that is the mandatory disclosure if you do not have malpractice insurance, professional liability insurance. Lawyers are only obligated, again, to make that disclosure if they do not have it. They don't need to make any disclosure if they do have it. And we've incorporated that requirement into Rule 1.4.2 as one of the disclosures. But the Regulation Subcommittee is recommending a series of other disclosures and that it be in a separate writing. So Linda,
I think, Greg, what you are doing right now is very helpful to identify what the subcommittee has identified as needing individual discussions and votes. But before diving into that discussion and individual issues on the controversial issues, should we just go through this list so everyone knows what is going to be separate, and then go on to what we hope to be a consensus group vote on everything else?
Sure. Sure. So Rule 1.5 is fees for legal services. This is nearly identical to the lawyer rule. We in California have adopted an unconscionability standard. The ABA model rule uses unreasonable as its standard for its ethical obligation in terms of the type of fee that a lawyer can charge a client. It could be either unconscionable, or it cannot be unconscionable or unlawful illegal fee. And what the subcommittee has done is essentially they have adopted the lawyer rule, but they've added one additional requirement. There's a set of factors that must be considered to determine whether or not the fee is in fact unconscionable. They've incorporated those factors from the lawyer rule and added an additional factor that you will see in the ABA version of this rule as well. And that is that it cannot exceed, that it's reasonable. If we had the rule up, I could say it specifically, but that the fee is not unreasonable in relation to what is charged in the community for similar services. And then fee 1.5.1 is the fee division among licensed paraprofessionals and lawyers who are not practicing in the same firm. That's an important distinction. The lawyer rule in California allows fee sharing among lawyers as long as they meet the requirements of the rules. What is not included in the lawyer rule is something that you will see in the ABA version. And the ABA version is under Rule 1.5E, Model Rule 1.5E. And that is that the fee division, the lawyers agreeing to the fee division either are only taking a fee in proportion to the legal services provided, or they're taking joint responsibility over the entire matter. Meaning if one lawyer were for any reason unable to provide the services, the other lawyer can step into that lawyer's shoes and provide the full panoply of services under the retention agreement. What the Regulation Subcommittee has decided is to have two separate provisions under Rule 1.5.1 for paraprofessionals. When it comes to fee sharing between paraprofessionals, who are not operating in the same firm, they have adopted that ABA model rule requirement. So they can only share the fee with the factors that you see in the California version of the rule, meaning the fee cannot increase by virtue of the fee sharing. It's just the terms and conditions are reasonable and fair. They're judged as being reasonably fair and disclosed to the client, and the role of each person in that agreement is disclosed to the client, and they obtain their informed consent. And what the regulation subcommittee has done is incorporated that ABA requirement that also the fee needs to be in proportion to the services provided, or they take joint responsibility over the entire matter. So what that means is when there's fee sharing between paraprofessionals, they can only enter into that agreement if the scope of services provided are within their licensure. They cannot agree to share fees in a matter where they know that the legal services needed from the client exceeds their ability to provide those services under their license. Compare that to what they've adopted for, are recommending that the working group adopt for fee sharing between a licensed paraprofessional and a lawyer operating in different firms. They incorporate the same requirements under the lawyer rule, but when it comes to that ABA requirement, they only will allow fee sharing between a lawyer and a paraprofessional if it's in proportion to the services provided, the fee that each one receives. They're not adopting this requirement or this ability to share fees by just simply taking joint responsibility over the entire matter. The reason being, there may be situations in which the paraprofessional could take joint responsibility over the entire matter, but as an additional public protection, they do not want to allow that because they don't want to put the paraprofessional in the position where they may take joint responsibility over matter, and the matter includes services that goes beyond their licensure. So it's a way of essentially corralling them in, and they can only take fees for services that they're licensed to provide. And those are the changes to Rule 1.5.1 that they're recommending. Do we want to move on?
Wait, okay. Hello.
I think I'm just being asked to provide an overview, and then we're going to have a discussion, Carolyn.
And an overview of the potentially controversial where there will be individual votes and further discussion.
Okay, but I appreciate your expertise, Greg, beyond words. I really do. I know you are an absolute expert in this area, and I really, really, really appreciate it. And Amos and Freba, again, you guys, it's just beyond words how much work this has been to do. But it's just going, this is very hard for me to focus on what you're saying with regard to each of these issues. And I've read a lot about this, and I can't even keep it in my mind. So I'm going to listen and everything, but I just, frankly, I'm having a hard time following you, even though I think I know a goodly amount of this. So please bear with it. You're going really fast.
And I'll just add, Carolyn, the subcommittee, so that's myself, Freba, and Kim, are ready, willing, and able to go into more detail on discussion of each of these points, because these are the ones that we think may need further discussion and explanation. So I think the purpose of this is to just identify these issues to make sure everyone understands these are not included in the group vote for all the other rules. So just to give you a high level overview now, and then we are more than willing and able and plan to go into discussion for each of these rules.
Okay, and we're going to do this and then go back and hopefully identify if either of us think there's more those controversial individual group vote rules, which is, I guess, going to be a thumbs up, thumbs down on 65 rules. I'll get to do that after we discuss these other ones.
Yeah, if there's any particular rule of professional conduct that you think is controversial or raises issues that need separate discussion, please do identify it, because we're happy to do that.
Okay. All right, we'll do this first and then that. I'm listening. Go ahead, Greg. I'm sorry to apologize. You're going really fast.
Well, I'm just trying to provide an overview. I mean, we can certainly go slower, but I think that's what Amos is suggesting, that once we provide sort of a landscape of, these are the rules that the subcommittee has identified as being potentially controversial for the working group. And if we can then, lead into a discussion around these rules, I think then we can turn to the other rules that you believe that are controversial and start identifying those. And if we need to talk about them in a future meeting, that's up to the working group and the chair. I'm not going to offer an opinion on that at all. I'm just trying to provide you an overview of how I presented the rules to them and what they thought. All right, so let's move on to Rule 5.3.1. Essentially, what the subcommittee has done is really adopted the same rule that applies to lawyers here. The reason they've identified it as potentially controversial, you can tell from the title, it has to do with the employment of disbarred, suspended, resigned, or involuntarily inactive lawyers or licensed paraprofessionals. The reason we have this rule for lawyers is to allow people who have been either suspended or disbarred from the profession, or for whatever reason needed to leave the profession, to be employed by law firms as a path to rehabilitation. But the concern, obviously there's public protection concern here, that the state bar be aware that these formerly licensed lawyers are working in a law firm. And so there's a requirement under the rule to provide notice to the state bar that the hiring has happened. And if they ever leave the firm, they need to provide notice to the state bar. You also need to provide a notice to each client that the affected lawyer may be, former lawyer may be working on their matter, and also disclosure as to what they're limited in the services that they're limited to provide. And that's all under the rule. But certainly this is a rule that probably should be discussed by the working group, because we're envisioning that paraprofessionals will own their own firms, and query whether or not we want them to be in a position where they're employing formerly disbarred attorneys or suspended attorneys. All right, moving to Rule 5.4. Obviously, this rule needs no introduction. This is an important rule for everyone to consider. The working group, there's something in the way of the slide right now.
I was going to say that, Linda.
There. Okay, thank you. All right, so there's many aspects to this rule, and we've gone through it before, but I think the most important one to highlight is that the subcommittee is recommending that paraprofessionals be allowed to own law firms, that they be allowed to amongst themselves, and also be allowed to co-own law firms with attorneys, so long as they maintain a minority interest in the law firm. And it also limits the paraprofessionals' ability to supervise lawyers within that law firm. They can't do that as well. Important point to note, and the way the rule is written, is that a paraprofessional firm that's only owned by paraprofessionals would not be allowed to employ lawyers under this rule. And then we'll move to Rule 7.2, the advertising rule. There's been changes to this to make sure that in every advertisement, paraprofessionals are including a statement that they are not a lawyer, and they're including their licensing numbers. And it also has to be included in the language of the advertisement. Solicitation of lawyers, 7.3, has been modified because one of the problems that we have, and this may be taken care of by statutory changes by the legislature, they're under the State Bar Act. It's a crime to operate as a runner and capper for a lawyer. It's also a crime to solicit somebody to act as your runner and capper as a lawyer. But there's no law right now, because this profession doesn't exist yet, prohibiting someone to act as a runner and capper for a paraprofessional, or for a paraprofessional to solicit somebody to do that. So this rule has been modified to close that regulatory gap. But we'll see. I mean, if the legislature decides that they want to support this program, and they pass a series of laws in order to stand up the program, they may just simply either amend the current provision on the State Bar Act, or pass a new provision that deals with this particular issue. Certainly the legislature is the only one in the position to make it a crime. We can't do that through a rule. But this would prohibit the paraprofessional from soliciting anyone to act as their runner and capper, or to act as a runner and capper for another paraprofessional. Sale of a law firm, the sale of a law practice, is the title of that Rule 1.17. That's the same title we use for lawyers. I think Steve Fleshman had concerns about using the term law practice. And I think that's one of the reasons he wanted to pull it out and have a discussion about that amongst the group. Essentially, with this rule, we are adopting the same rule, and that applies to lawyers. The purpose of the rule is really to protect solo and small firms, practitioners. There was no, it was always an ethical obstacle course for solo practitioners to figure out how they could ethically transfer ownership in their practice. A lot easier for lawyers in larger firms where they have a lot of equity partners. So essentially what this rule does is it provides a roadmap for small firm lawyers to do that in an ethical way that protects the client, protects their confidentiality and their client files, and make sure that they're doing the right thing to transfer the matter, or at least provide the client the opportunity to decide whether or not they wish to transfer the matter to the buyer of the firm or to obtain new counsel. So that is my soliloquy on the 10 rules. Do we want to go back and start back with the first set of rules, Amos?
Yeah, I think so. And again, just for context, I may have misspoke a bit earlier. I do not think the regulation subcommittee believes all of these 10 rules are controversial. I think we pulled the ones that we think might be controversial. Certainly 1.5.1, the sharing fees, and 5.4 are controversial. The other rules we pulled either because they might be controversial or they're just new rules that don't exist for attorneys. And we wanted to pull them out for discussion and highlight them and talk about why we are recommending them. All of the other rules that I'm hoping that we are able to address next are rules that apply to attorneys, and that if there are any changes at all, it was changing paraprofessional to attorney to paraprofessional, or eliminating them if they just don't apply because of the limited license being proposed, or eliminating cross references to statutes that don't apply, or something similar to that. I don't know if that's an overgeneralization. Greg, help me if that is, but that's the idea, is anything that's controversial or any new rules that we're adopting or that we're recommending for paraprofessionals are in this list of 10. Everything else fairly tracks the rules for attorneys.
That's correct. So Amos, do you want to, where do you want to go from here? Do you want to talk about the first 3 rules that we had up?
So I think it would be better if we go to the group vote and save this discussion of the controversial to after, but I think the request was made for another opportunity to identify any other rules that should be added to this list of an individual discussion.
Well, and understanding that, we had one that was identified, and maybe someone wants to identify another one now, but it's not that people can't, when we're looking at the batch, say, hold up a minute, I really think this one needs to be pulled out. I want to make it very clear that from my viewpoint, this is not like speak now or forever hold your peace.
Oh.
And I have a hard time seeing hands because of the sidebar. Carolyn, is your hand up?
Yeah, and because my first motion was so soundly met with complete silence, I'm just wondering, rather than belabor every little point that I personally feel might be worth discussing, if there are no other thoughts, I'm always the first one to raise my hand and kibitz. I'll wait here and see if there's anything else anybody would want to pull out. My vote will be every single one of these needs to be pulled out and looked at carefully. So with that being said, I urge others to think about giving the public some time to go through these more than 3 weeks.
And I just want to say one thing about this, though, because I don't think it was ever the concept to have the entire group look at every rule in great detail. There would have been no purpose whatsoever for having the subcommittee that has been working diligently on this to help put this into buckets and to help identify what needs to be done. And again, though, that being said, I really would like to encourage people, even if they haven't seen this before, even if they haven't identified already in their head something to pull out, that while we're going through the discussion, they should do that. And I know I'm not a voting member of the group, but I'm going to allow myself to do the same. If I see one that I haven't seen before that I think this needs to be pulled out, I'm going to say it. But again, I mean, you know, it was the function of the working group to go through this one by one, which I can attest as an eyewitness to much of it, that they have actually done. And they're all still speaking to each other somehow. Judge Yu.
I wanted to just thank the group, the subcommittee, for doing so much work. I read through this because I've been on a plane a lot, going there and coming back, and I just was really impressed with how much work and how much thoughtfulness there was, and how careful it was and how clear it was. It was really clear to me that what a group vote was a group vote, and the individual issues were, you know, things that people could talk about, and that there was an introductory statement that we could pull things out if we wanted to. So I'm just very grateful, and I think it's very comprehensive and very clear.
So for purposes of the group vote, what was anticipated that we do at this point? Are you going to put up, you know, page by page? Is there how are we moving forward?
Well, I don't know if it's appropriate for me at this time, but I'm willing to make a motion that those that have been identified for group vote, sort of like not really a consent agenda, but akin to that, that those put up for a group vote be approved. That would be my
Okay,
motion.
and thank you for doing that, because you're reminding me of a side conversation, not a side conversation because it was a public conversation in the subcommittee meeting. But I was, you know, participating in the committee meeting on Thursday, and the protocol was raised as far as whether there should be a motion and second and then discussion, or whether sometimes we've really started in on discussion and then tried to do moving motions. And so it was my recommendation that we go ahead and get a motion at the outset and then have discussion. And if we can have friendly amendments, or, you know, if someone wants to make a friendly amendment, that can absolutely happen. But before we take anyone else who wants to make substantive comment or discussion, is there a second to Judge Yu's motion to move to approve the set of rules, of course, not the ones that have been identified as being on hold for further discussion?
I second the motion.
Okay. And so Linda, you got that?
Yes.
And was there a comment you wanted to make as well, or was it a second the motion?
It was just a second the motion.
Okay.
And just
so with that, I'm going to call for discussion, and I see Ira has his hand up.
Yeah, I just have a question about the motion. Is it a motion to approve the ones that are designated as not controversial?
No, the motion is to approve those that are noted for a group vote.
Well, then I'll ask Amos or whoever else knows, is that the ones designated for a group vote, those are the ones that the subcommittee thought were not controversial. Am I right?
Yep, you're right.
Okay.
Correct. Everything else besides the ones that Greg just highlighted. And it might be helpful, Linda, to put up the chart of all the rules.
Okay, I can do that.
You each should also have a clean set of the rules and a redlined version of the rules against the attorney rules.
And just to add to that, Amos's comment, the red line is really helpful to see where a section is brand new, completely rewritten, or just the word lawyer is replaced with licensed paraprofessional, which makes it not controversial from that aspect.
And this, of course, does not include 1.17, the one that Stephen Fleischman identified after the agenda item was posted.
And Ira, maybe just for clarity, there's 71 rules and there's 10 right now that are we've identified as controversial, ones that we would like to take independent votes on. So you're looking at the 61 that are for group vote. I believe that's right.
And as the mover of the motion, I agree with what Linda said. It doesn't include the one that was identified afterwards by Steve Fleischman.
As the person who seconded the motion, I agree. I second that.
So are there questions, or Greg, does it make sense to just quickly walk through these rules? Again, everyone has these in their materials, including the chart and including the red line rules. And the idea is just for convenience, this is the comparative of whether it is the same or slightly modified from the parallel rule for attorneys. But the idea is, at least the approach of the subcommittee was the attorney rules were the minimum. And the question was, does it apply at all? And some didn't apply at all because just as the limited nature of the practice, if it's criminal law or something like that. But for the rules that applied, it's the same or minor changes.
Amos, you asked, does it make sense to go through these? And you know, I would posit that we're all professionals and we've read it, so I don't think it's necessary.
Oh, and I just wanted to make a point of order of clarification. When you said consent, Your Honor, Erica, what did you mean by that? Is that a not a roll call vote, or?
No, I'm just saying akin to. So I'm not saying this is a consent motion. I'm saying the motion is to approve those in the chart that have been identified for group vote, other than the one which Linda discussed already.
Okay, thank you.
Sure.
Yeah, and I'm happy to answer any questions that anyone might have about a particular rule, but I think that the idea of putting them on for group vote was to avoid a deep discussion on each one of them, unless people wanted that.
Julie has her hand raised.
Thanks. Are we at the point where we should comment on group vote items and/or questions? Okay. I just have a question on Rule 1.83, gifts from clients.
Can you give us just a second to get it up on the screen so we can look at it while you're talking?
Sure.
Sorry, I'm working on bringing it up.
No, and it's okay. This is just an editorial change. I just think there's an editor's error.
And which one is it?
1.83.
1.8.3, gifts from clients. This is not going to be worth the trouble, but we'll go.
Oh, it will be.
Sorry, I have all the rules as one document, so I'm just looking.
Oh,
I think I already see what your suggestion is. Is there an extra or?
It's on the
yeah. You were trying to wipe out a sub B.
Yeah.
But in a sub A there's a there's a comma or at the end, so you just want to get rid of that.
Yeah.
And I have one other slightly more substantive one after you get to this one.
Oh, sorry. Let's see.
I'm not sure. Okay, everyone needs to see that. We
Yeah,
got that's a definite error. So,
yeah.
What's the second one?
It's the second one that I picked out is Rule 3.5, which is designated as group vote. It's entitled "Contact with Judges, Officials, and Employees." And last I heard, we voted to allow in-court representation in some of these practice areas. And I believe the practice area groups are going through area by area to decide or to make recommendations.
But at the very least, in some of these areas, we contemplated that the judge would be able to ask a direct question of the paraprofessional and the paraprofessional could answer. And I'm not sure this rule 3.5 addresses that. And maybe we just want to pull it for a separate discussion, or maybe I'm just wrong and you can correct me.
Well, the purpose of this rule, it has to do with the ethical line you cannot cross when you're trying to contact a judge. So this is the no ex parte communications. You cannot lend or provide anything of value to a judge as a way to try to influence the judge, official, or employee of a tribunal. And then the B has to do with what I was saying earlier, directly or indirectly trying to communicate with or argue with a judge or judicial officer on the merits of a contested matter that's pending before them, except, and then I don't know why 1 is struck, because that was actually not struck in my version that I had before, but that's in open court with the consent of counsel, in writing and with a copy furnished to the all other unrepresented or represented parties in the matter or in ex parte matters. What was struck in my version had to do with jury trials, because my understanding is that the paraprofessionals would not be representing counsel in jury trials. So the prohibitions on communicating with jurors or attempting to communicate with jurors was not going to be part of this rule.
If I could suggest a friendly amendment or to remove 3.5 for individual discussion, it does look like that's worth a further discussion and maybe some edits. Certainly the intent is the rule would be the same for lawyers and paraprofessionals. And if either a lawyer or a paraprofessional is asked a direct question by a judge, that it would be appropriate to answer.
Thank you. I think that's appropriate, Amos. Thanks.
Ira?
Yeah. Well, it was already pointed out, Amos, I think, just pointed out that B1 in open court should not be stricken.
It's not in my version, Ira. That's what I was pointing out.
Oh, it was great. And that would take care of the problem with answering questions in court.
Mm-hmm.
And then I don't see why 3 and 5 were stricken. 3 for everybody is, these are situations where the paraprofessional or lawyer is allowed to argue to the court. So 3 is in the presence of all other counsel and any unrepresented parties. It seems to me that applies to paraprofessionals. And 5 is in ex parte matters. And I can see how, I don't remember exactly the scope of what paraprofessionals can do in courts, but probably it includes some ex parte matters. So I think that should stay in too.
Amos, I think your suggestion was to pull 3.5 out of the group vote, right? And so then Ira, we would set substantive discussion of 3.5 aside for now. So we've identified that this is an additional item for an individual vote. And I think what we have is a motion and a second on the group vote. We have some discussion that's resulted in another rule being pulled out of the group vote. And if there are no other comments, I think we could take a vote on the group vote item.
Well, first of all, hold on one second. Judge, you and her second need to accept the amendment to the motion to pull out that one rule that I just identified.
Okay.
And I'm happy to do that.
And I'm happy to second her motion as amended.
Okay, so are there other folks who would like to be, and I can't see anyone but one person at a time right now on my screen. So if there's someone else, I'm trying to see if there's a different way for me to look at this.
Carolyn has indicated.
I see your hand up on the side.
Yeah. Okay. So I'm going to start with, I mean, I could just give a list and of the things that I think should be pulled out. I mean, I don't like this whole procedure, this group vote. I think I've made that clear. But I think 1.1 needs to be pulled out, the definition of competence. I don't know that that's been discussed in terms of what that really means with regard to a paraprofessional until we see some of the other, till everything is decided. I don't know how we're going to know what competence is. Then there's a whole bunch of them. And you don't have the other, I'm trying to actually read the actual rule. But I guess I can go back up to the chart because sometimes this chart does not jog my memory as to what the actual rule says. So I'm jumping back and forth here. I'm looking back at the chart to see what was deemed. Okay, so I think there's also 1.4, communication with clients. I think that also has to be decided and discussed with regard to 1.4.2, the notice issues. So I don't know how you need to discuss those together in terms of what's going to be important to the community at large, writ large, and us internally. So I think that needs to be done with the other 4 series. You've already pulled out 1.52. Oh, is 1.5 itself pulled out, or fees relief? Okay, that one's pulled out. I'm trying to go through these as fast as I can, but I think.
Well, and I don't want to be, I obviously don't want to be rude, but people were expecting. I mean, we can't use the group time for everyone to individually go through these. I mean, there was an expectation that, and I appreciate that would have included weekend time, but that these be reviewed in advance of the meeting today.
It included a Friday time, yes, and a weekday time, Your Honor. And what I heard in the regulation was you're going to go through these one by one in the Thursday meeting, and then that's what I thought everybody was doing, is going through, and Amos was saying, well, this will be controversial and that'll be controversial. And I really thought.
So I'm sorry if there was a miscommunication or a misdirect on that, but no one ever thought, oh, I certainly will speak for myself, that we were going to go through every single one of these groups and the whole rules in the whole group, because again, why have the subcommittee then? That's what they were there for.
Well, but that assumes that we'd all rubber stamp everything that the subcommittee would do. And I don't think anybody would think that that's doing a good job as a working group. This is one of the most important parts of our program, if not the most important part. This will discuss and describe how everybody does everything henceforth forever, with the review of the Supreme Court, with review of the appellate groups that the licensing, not the licensing, but the disciplinary group does. This is the thing that we should be discussing absolutely last. But Your Honor, I agree. I just, maybe I make a note that I think there's at least a dozen of these that need to be pulled out. And I just don't know how to effectively communicate that with the time that I had to make an entire memo and a list to everybody. And I get voted down anyway. So if anybody has any others to add, then if nobody has any.
Ira, I see Ira has his hand raised.
I'll need a second on my motion. So I don't know what the point, I'm wasting my breath.
I'm sorry, just to clarify, you pulled off 1.4, right?
I think 1.1, but also 1.4.
Yeah, and we haven't pulled anything out short of the person who made the motion agreeing to that. And so before we turn to that, though, Ira's had his hand up, so we'd like to hear from him. Ira, I believe you're muted.
I'm saying this for the benefit of the public listening, as well as, well, not so much for the members, because we all, I think, should have read this stuff. Maybe we all didn't have time. But the ones that are not controversial, that are being voted on together in this one single vote, we're going to have, is they're in large part simply the same as the rules that apply to lawyers. And to the extent they're not, they're almost entirely just modifying the lawyer rules so that they apply in their words correctly to paraprofessionals. In other words, adapting them to what paraprofessionals can do and cannot do. And so nearly everything in this group vote is formalistic. All the ones we're going to vote on are formalistic adaptations of the lawyer rules.
And before we turn to Julia, would any of the committee members like to respond in regards to 1.1 and 1.4? What I heard Carolyn saying, and she can correct me if I'm wrong, was that aside from wanting to look at these one by one, that it was her belief that we needed to have finalized all of the recommendations for all of the subject matters before taking these up. Carolyn, am I speaking out of turn, or is that correct?
Well, I think I don't want to, again, I don't want to waste everybody's time.
Well, but
I really don't. If I'm going to go through these and I'm really the only one, Your Honor, who has, a comment to make, I think that's not a fruitful use of our time. If nobody's going to second these things that I suggest, I don't, if everyone has it in their mind that they want to do group vote, and
well, but it's not that folks have it in their mind and want to do group vote. I mean, I think you raised an issue, and personally, I would like to hear from the subcommittee folks about their views, because that informs whether Judge Yu carves out 1.1 and 1.4 or not. And so I'd like to hear from the subcommittee folks whether or why it is that they felt that we could vote on this now before having finalized, for example, family.
Justice Petro, could I speak
Sure.
to the competence one?
Sure.
Since I wasn't in the subcommittee with them, I don't know what their discussion is, but as chairperson of the licensing subcommittee, the thing I feel comfortable with the competency is the fact that unless a paraprofessional gets qualified in a particular subject matter and passes their exam, they can't even be doing that kind of practice. So in response to Carolyn and her concern over the definition of competence, I think through licensing, they are only going to be competent and licensed to practice in the areas after fulfilling all of the licensing requirements.
All right, Sharon?
So I did do my homework and I reviewed these over the weekend. I thought that the group did a good job and I didn't have like any major issues, but I also realized that I may have blind spots. The one that I had the most questions with was Rule 1.4.2, and that has to do with the alternative choices. So with this, is it just contemplated that will be I guess like written disclosure that they, as a consumer, may have alternative choices, but are they actually required to give a list of the family law facilitators offices, like contact information and local legal aid organizations? Because I know that this has been a concern of legal aid.
Yeah, absolutely. There's been, and Greg, I'm going to turn to you next. Absolutely, there's been that issue, and I'm going to let Greg respond to that, to the 1.1 if he wishes, 1.4 and the 1.42. Actually, I'm going to hold my comment and let him do that first. Greg,
can I just interject that 1.4.2 is not part of the group vote?
That's right. That's what I was going to.
We're gonna be talking about that separately.
Yeah, that is one that is identified as potentially controversial, for the reasons you called out, Sharon, in some respects. Turning to Rule 1.1, perhaps it would be helpful, Linda, if you brought up Rule 1.1. I could just talk about this rule, what it does and does not do. It is an ethical rule. It's not the same as the standard that is applied in a malpractice case. not necessarily the same standard that's used in licensing decisions. The rule of competence for lawyers in California is that they shall not intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. What you'll notice from this rule is that it doesn't say that it does allow for a single act of simple incompetence under the rule, which means we do not discipline a lawyer if they make a mistake, because there are other remedies for that in California. That is malpractice, right? So competence is defined under B as applying the learning and skill needed for that particular matter, but it also includes your mental, emotional, and physical ability to reasonably provide those legal services. So it's a broader concept than just having the learning and skill to provide competent legal services. The other thing that I'll point out, what C does is essentially allow if you're not currently competent under the lawyer rule, you can become competent because you're omnicompetent, right? So a family law attorney could provide competent criminal defense as long as they study up and make sure that they associate with counsel, do the things that they need to do in order to provide competent legal services. This assumes, though, that you're still acting within the scope of your licensure, obviously. So a paraprofessional is not off the hook because they suddenly picked up a criminal procedure book and learned how to defend somebody in a criminal case. That obviously would run afoul of several rules and several statutes. What the subcommittee decided to do, though, is not allow for D to exist in the paraprofessional version of the rule. And D allows a lawyer in an emergency situation to provide legal services, and it's essentially it's a safe harbor for them from A. And paraprofessionals are not going to be afforded this safe harbor, so they have imposed a higher standard on paraprofessionals than the standard that applies to lawyers here. So that is what the purpose of A is. I don't believe A is going to change depending on the scope of licensure, really, because it's a standard that would apply in all cases, assuming that the paraprofessional is always operating within their licensure. So that's the only comment I'll make about 1.1. We could also talk about 1.4, but I wanted to let anyone ask any questions about 1.1.
Ira has his hand raised. Oh, you did. No, okay.
Okay, well, let's go to 1.4 then. 1.4 is the communication rule. And it essentially, the group has, the subcommittee has adopted the same rule that applies to lawyers. And this is the attorney, in this case, licensed paraprofessional's duty to communicate, promptly inform your client of any decision or circumstance where they need to obtain the informed consent. They also need reasonably consult with their attorney about the means that are being used to meet the client's objectives. Normally, lawyers have a broad discretion in terms of deciding the means, but they need to reasonably consult with their client so they are aware of the means that are going to be employed in the representation. That's the same standard that would apply to licensed paraprofessionals under this rule. A3 is where we see a lot of disciplinary cases, and that is to keep your client reasonably informed of significant developments relating to the representation. Usually when an attorney essentially ghosts their client, never returns their calls, this is one of the charges that we see in those kind of disciplinary cases. And that includes complying with reasonable requests for information and copies of significant documents so that they can stay informed. You need to advise your client about any relevant limitation on their conduct that they know the client expects assistance with. This would also include if the client is expecting them to exceed the scope of their representation. Certainly they're restricted under Rule 5.5, which is the UPL rule, but they also have to tell the client that they're restricted under that. And there's a couple different places in the rules that impose this ethical obligation on the paraprofessional, not just Rule 1.4. They need to, under B, reasonably explain the matter to their client, reasonably explain it to the extent that they need to obtain their informed consent to proceed. And there's a, under C, they can delay the transmission of information if they reasonably believe a client would react in a way that might cause imminent harm to the client or others. This is a more recent, when I say recent, it's in the last decade, I think, amendment to Rule 1.4 to allow for those situations where they're concerned that the conveying of the information might cause harm. And then D essentially imposes the obligation to provide information and documents that is subject to any applicable protective order or non-disclosure agreement. And that is essentially what 1.4 does. And it's again, the same rule that applies to attorneys. So that's the reason it was placed on the group vote list.
I guess, thank you, Greg. And I forgot to mention Kim. I know I forgot to thank you for your work on this, because I agree. This is a phenomenal amount of work. And I agree with so many of these. So many of these are excellent changes, and so many are, a lot of this is really tremendous, and I get it. And I get where you're coming from on a lot of these. I just see some of these as being more controversial. And I guess the point was it'd be more controversial amongst us, not the public. Is that sort of where the individual group distinction made?
It's an opportunity for the working group members to identify the point of controversy. So I think it would be helpful to know what you believe is the point of controversy with regards to Rule 1.1 or 1.4.
I think it ties into the other ones that you said are controversial. So I think you can't discuss 1.4.1, 2, and 3 without really talking about communication. One of my things what I think is going to be controversial, listening to all the public service entities, legal services organizations, is that disclosure and what that disclosure is going to say. I know it was discussed, the particulars and, a flyer or a fee agreement or whatever, as to particular things that were going to need to be said or want to be said. I don't see that anywhere in terms of the rule itself. That's one thing that I think is going to be something that the legal services organizations are going, have expressed an interest in their public comment about. So I would my point is 1.4, I think, should be added in the mix with the other 1.4s.
We have a few hands up, Justice Petru, including Judge Yu. I don't know if she.
No, I see that. I think Judge Yu was, so we'll be sure to get her. She does have to leave us at 4. Let me hear from a couple of folks we haven't heard from yet. Claudia. Claudia, I'm not able to hear you if you're speaking. You appear to be muted.
Yes,
Oh,
I
there
was.
you go.
Thank you. Thank you. I just want to speak to the content that we are covering. Thank you to the committee for putting this 100+ page report together. Very intense. I took quite a bit of time reading it, trying to understand it. And I'm speaking just as a consumer here, obviously not as a trained lawyer, for as you know, I'm not. To me, almost everything seems controversial, but that's because I'm not informed about the law. So knowing that there are so many limitations already just for you all lawyers, it gives me some relief that there's a basis to go off of. So pretty great foundation. I wish that I understood things more deeply, because I do feel a distressed hesitation about having to vote on all of these things. So I echo the earlier motion, but again, I can't fully trust my apprehension here, for I'm not totally informed as to, how drastic of a change is being had here. But I do thank you for putting this report together so that I can continue nerding out on it and trying to understand deeper. So I love it. And thank you for the strike through language as well. The whole thing, once you see it in its entirety, I feel it's a great playbook. But
I
And I
keep
have
on
to
studying
echo,
for time.
that the strike through, I could not go through it without the strike through version. There's no way.
I needed that. Thank you. That really helped me to value the work that you all did. So thank you for that.
I thank you, Claudia. Kimberly.
I just wanted to point out to the point of the public comment that I was listening during the public comment section and taking notes. And I believe that every public comment that came up was on an item that actually we have pulled out into the 9 that we had originally pulled out for discussion. So I'm sure that there could be individuals that have a few in the other group, but I did just want to cover that because that seems to be a concern from individuals. So wanted to make sure everybody knew that. From my looking at it, it looks like we've covered most that people have brought up.
All right, thank you. Judge, you, or other than what's already been removed and put into the bucket of to be discussed one by one in great detail, are there any others that you would like to remove from your omnibus vote?
No, I'm so appreciative of what Claudia shared, and I'm wondering if she feels comfortable with us moving forward with what Ira said, because I see it the same way Ira does, which is that when I went through the chart and then read through the strikeout version, because the red line version helped me, is that a lot of these are just the same rule for the lawyers, or some of the words they don't apply because we know that the paraprofessionals aren't going to do jury trials, for example, and they're not going to go on the bench as a judge. So to me, it seems like these are kind of pretty straightforward, but I just wanted to just check in with her and see if she feels comfortable if we move forward.
Thank you. Thank you. Yes, they, them, but yes, I do feel comfortable based on how everything is written. Like I said, I feel like I need to keep studying this for the rest of my life to fully understand. But the strike through language does help me understand what the changes are specifically. And I think that that's what we are voting on at the moment. So
okay,
I feel good about it.
Thank you.
And thank you for the they, them correction.
No, I have to add it to my profile. I keep forgetting.
I have it on my screen, but it doesn't show up on this in this meeting. So
exactly, of course.
Okay, Ira.
Yeah, I've seen something in 1.4.1, which is still in the group one, right? Eliminated. This is the one about
Communication of settlement offers.
Yeah, communication of settlement offers. And what's eliminated here from the lawyer rule is a definition of client for purposes of 1.4.1 and eliminates the definitions as anybody who possesses the authority to accept a settlement offer. And I can see why that was done because the paraprofessionals aren't representing organizations, but it occurred to me, what if the client has a guardian ad litem or some other kind of person who can act for the individual who is the client? So I think B needs to go back in except for the class action part.
Someone, Greg or someone from the group to respond, please.
Am I on mute? Oh, no. I see that, I think that's a very good point, Ira. What I would want to do is make sure that we look at the definition of person then, which I think we may have edited. Yeah, so person has the same stated meaning in Evidence Code 175. So I think we should probably, that's a good catch, because I think you're right. I think there may be situations in which there's another individual who is making decisions on behalf, authorized to make decisions on behalf of the client. We may want to, in addition to that, take another look at the definition of person and see if that still works.
You know, I just realized it could even be a bank, for instance, that has the authority. So maybe person, I think person is, well, I don't want to say I think, look at it. But anyway, you get the idea.
Mm-hmm.
So does the motion that's currently up reflect all the rules that?
Let's wait a second. I'd like to finish where we are. Greg,
is there something further on the 1.4.1 that Ira raised, or any modifications that you feel like we need to make at this time?
I think we should consider whether or not we want to pull this one out as well. This is exactly what this process was hoping to do, is identify this. I think we need to probably take a look at this rule, take a look at B specifically and see what, because I understand what he's doing, but
Okay. So that is 1.4.1 communication of settlement offers. Is that correct?
That's correct.
Yeah.
Okay, and Judge Yu, do you accept that amendment?
Yes, I do.
Okay, and your second, Julie, as well?
Yes.
Okay,
And then I thought Steve Fleischman's hand was up.
I don't see it.
It became moot, Erica.
Someone read your mind and responded?
Greg did, yeah.
Okay, so going back to then, Linda was about to ask whether what is up is correct. That the exception of the following rules, 1.4.1, 1.4.2, 1.4.3, 1.5.2. Can we put that in a different order? Yeah.
Yes, I just had it in order of the slide, but I will move that.
Okay. 1.5, 1.5.1, then 1.5.2, and so on, 5.3.1, 5.4, 7.2, 7.3, and then can we move 1.17 where it would belong?
Yes.
And 3.5, is that correct? Anyone from the committee or someone else think that something is not listed there that needs to be?
That is correct. We can change the order of 3.5 as well.
Carolyn has her hand up.
Carolyn?
I'm a horrible person. I'm really sorry.
No, you're not.
I'm like the fly in the ointment here, and I apologize. And part of it is just my nature. I'm like Claudia said, I'm a nerd completely. I do have more, and they're basically, this is again what's controversial, not what I agree and disagree with. Because
understood.
Yeah, but I think there was the most important one. I thought is 7.1 should be added to the 7 series. Those are the ones that deal with advertising, solicitation, and to scroll down to it, I have others, but this is the most important one to me.
So 7.1 is communications concerning licensed paraprofessional services, and that is the same as the attorney standard. So is there something in there that you think should not be the same as the attorney standard regarding communications?
It is with the ABA and with these rules and California rules, it is intimately connected with advertising, because when you make a false statement that relates to advertising,
sure.
This again, it's not my disagreement with the content of the rule. It's just to say that I think this with the others bears further discussion with the 7 series. It should be lumped into there and pulled out.
Okay, could I hear from someone from the committee?
The only thing I will say about 7.1 is the purpose of 7.1 is to establish the standard for the type of communication that's forbidden, and that is they cannot make a false or misleading statement regarding their services or themselves, and that is then cross-referred in the advertising rule, the solicitation rule. I think there's a rule on firm names and letterhead and things like that. So it's
right.
It's similar to 1.1 in terms of establishing a broadly applicable standard, and then it's incorporated more specifically into other rules as a standard.
And is it only subdivisions A and B? Yeah, it's just A and B, what's up on the screen right now, correct?
Yeah, that is correct. And B essentially authorizes the board to formulate any standards that they believe, and this is essentially a standards that the violation of which you presume it is false and misleading if you violate that standard.
Right. So 7.1 is simply saying that licensed paraprofessional shall not make a false or misleading communication. And then the subsequent rules go into detail regarding, in what context and how. Okay, so Judge Yu, do you wish to pull 7.1 out?
I don't really see a need.
Okay. All right, Linda, let's go ahead and take the vote.
I'm not.
Oh, sorry. I was looking for hands.
I'm sorry, I didn't, well, it's,
How many, can you give me the list?
It's, and again, yes, and then maybe Judge Yu is familiar enough with these that we can.
Well, and she's leaving us in 9 minutes, so we'll have to figure out what to do if we haven't had a chance
Yeah,
to
I
vote
mean, I've
without her.
got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
Okay,
12.
and none of these were sent to us before the meeting today?
Your Honor, I had things to do with my children that I was unavailable to get to internet, much less I was running around with a band doing, I made scrambled eggs for 150
Okay,
kids.
so what is the list?
Okay, I apologize. This whole weekend from Friday afternoon through Sunday night at midnight.
Could you give, okay,
ready.
And not to cut you off, but we are very short on time, so I'd like to focus on the list, not your activities.
This is, okay, I'll try and read them in the order that they go in the way they go in them. 1.8.11, 1.10.
1.10.
Right. Backing up out of order, 1.7, 1.13, 1.18, 3.1, 3.6, 4.4, and then around the fives, 5.1, 5.2, 5.3, and 5.5. And most of those are because I think they have to be connected to others that were deemed controversial.
Okay. And these are all ones that are not currently on the list. So let's go ahead and pull up 1.8.11.
May I ask a question of Carolyn, though?
Of course.
Carolyn, are you thinking that this is like the last one? You just want them all discussed together? Or do you have specific issues with these that you've just enumerated?
I would say 85% of these are things that I think, these are the things that go together. There are a few in here, but I think 85 to 90% of these are the things that belong together, especially with the 5-point series. And again, that would be my next most important collection of matters, because we know already 5.4 is perhaps the most incendiary one of all.
Okay, thanks for explaining. And I just want to apologize because I have case conference at 4 and there's lawyers and justice partners, so I can't reschedule that. And I've been up since 3:30 in the morning, East Coast time, because I specifically wanted to attend this meeting and get here on time, but I won't be able to see this motion get to a vote. And I think that's probably okay, because I'm sure there's others who will step forward. But I apologize that I'll have to leave at 4.
I'm sorry, Your Honor. I apologize. I really respect you, and this is not my intention.
Okay, I believe Judge Rubin indicated to me that he would be willing to take on being the mover. If that is acceptable to Judge Yu and to the second Julie, is that okay with both of you?
Yes, and I was just going to say, if it ends up when we're discussing the individual rules that we have to revisit, I am open to doing that. But to progress forward, I would like to take a vote, and I will not be seconding that friendly amendment. I think if those end up coming into play, when we have our individual discussions, we're free to raise it then.
This is Judge Rubin. I agree with Ms. Finelson.
Yeah, I actually agree with Julia too. That makes a lot of sense, and that hopefully will get us together today. But I'm going to vote. Let's do it.
Okay. All right, in which case we're going to stick, we still have Judge Yu, so we're not going to prematurely kick her off.
Thank you.
Linda, you can go ahead.
Okay. Bashan,
Yes.
Brynelson,
Yes.
Felmuth,
Yes.
Fleischman,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
and Dana said that she has a power outage, so she had to leave. Olvera,
Yes.
Robinson, I'm not sure if Nicole is still. Nicole, are you able to unmute yourself to vote? Okay. Ted Rubin,
Yes.
Shining,
No.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
and Judge Yu.
Yes, thank you, Linda. And thank you,
Motion
Jessica.
carries.
Thank you, everybody.
Thank you, Judge Yu.
Thank you.
Judge Yu, before you go, I'm just going to say that if you ever are the last person to vote and fail to thank the person calling roll, I'm going to fall over in shock. So thank you for even on being on no sleep and having traveled all day for remembering to do that, because I don't always, and I very much appreciate that you do. So we're going to give you a big 3 minutes before you need to go to your next meeting.
Okay, thanks. Take care, everybody. Bye-bye.
Bye-bye.
Hello, Judge. I'm sorry. I was trying to unmute myself. This is Nicole.
And Nicole, what was your vote on it?
Yes.
All right, thank you very much. Linda,
Thank
were you
you.
able to hear that? Yes.
Yes, thank you.
Okay, I think, and I apologize as chair, I should not have let us go for 3 hours without taking a break. So I'm going to call a 10-minute break and we'll reconvene at 4:10, okay? And Leah, I'm going to try to touch base with you during these 10 minutes about the last hour.
Sure.
All right, thank you. Okay, let's hop back on. Could folks turn on their videos just so I know that we're back in action? Okay. So I think what I would like to do is take a short pause, or potentially a longer pause, from the individual regulatory licensing items, and turn to family and housing, which I think have relatively discrete, relatively non-controversial matters for us to discuss. So let's do that and then see what time we are at. We are clearly not going to go through many, if any at all, of the remaining regulatory items today. We'll do that at our end of August longer meeting. So starting with family, who's presenting on that?
I am, Your Honor. This is Fariba.
And Fariba, I think you are muted.
Am I muted?
Oh, we can hear you. I can.
Okay.
Yes.
All right. Good. Thank you very much, Your Honor. So we have two resolutions for consideration today. I'm going to take them one by one. Linda, if you could please bring up the first one regarding appointed counsel. Thank you. So at the last meeting, we put forth a resolution to exclude being appointed as minors counsel as a task that's allowed in a family law specialization for paraprofessionals. After that, it came to my attention that appointed counsel in relevant areas for our field, there are two additional code sections that allow for that. One, family code section 7860, that provides for appointment of counsel in matters where paternity, substituting parentage is at issue, and counsel can be appointed for the parent as well as for the child. And in probate code 1470, the court can appoint counsel for a ward in a guardianship matter and for a conservative or proposed conservative in a conservatorship matter. So to be consistent, we have a resolution here where basically we're excluding work as appointed counsel in case that within our purview, which are basically the three sections I just pointed out, and any sections that may be added in the future. So therefore, I move to adopt the resolution as stated on the screen. Is there a second?
Second.
Steve Fleshman, thank you very much. Discussion? Let me just check my.
Yeah, I realized I was looking at the wrong screen.
Okay. I don't see any hands, Your Honor. Do you? Anybody?
I don't either.
Okay, could we take a vote, Linda, please?
Yes. Bashan,
Yes.
Bernelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton. Oh, I'm sorry, he's not here. Hartston,
Yes.
Kirkmeyer,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Ted Rubin,
Yes.
Shining,
Yes.
Sarouche,
Yes.
Torres Ambris,
Yes.
Judge Wiley.
Yes.
Motion carries.
I didn't get to vote.
Oh, I'm sorry, Ira, I thought I called you. I apologize.
I vote yes.
Okay, thank you, I apologize.
Thank you very much.
Unintentional oversight.
Thank you. Linda, could you put up the next resolution, please? All right. Also at our June 10th meeting, we had a resolution to include as allowable task, authorized task for paraprofessionals violence prevention work. We had talked about elder abuse at our meeting, but it was inadvertently left off the list. That was included in the resolution on June 10th. So here we have an amended resolution that basically adds elder abuse to the list of violence prevention work that is going to be allowed. And here today, I just want to mention is actually elder or dependent adult abuse. And I would like to add that to the resolution. I know members of my committee, my subcommittee, you may remember are discussing it, but we didn't discuss it at the very last meeting we had. If you have any comments, questions, please ask now. Okay, so therefore, I move to adopt the resolution as amended to add elder or dependent adult abuse as allowable authorized task under the violence prevention category.
Second.
Thank you, Mr. Flashman. Is there any discussion? Any hands? I'm just going to go up and down my screen here. All right, I don't see any. Linda, please, could you take a vote?
Bashan,
Yes.
Fernelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton. Oh, God, I did it again. Sorry about that. Hartston,
Yes.
Kirkmeyer,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Ted Rubin,
Said yes.
Sarush,
Yes.
Spiro,
Yes.
Torres Ambrise,
Yes.
Judge Wiley.
Yes.
The motion carries.
Wait, you skipped me again. You skipped me this time.
Oh, I'm sorry.
You got the S's.
Oh, sorry, I was Shining.
No.
Okay. Okay, sorry about that. I think I'm getting cross-eyed here. Okay, the motion carries.
Thank you very much, Your Honor. I'm done.
Okay, thank you. All right, moving to housing. Who's presenting on that?
I believe I am, Your Honor.
Okay, Amos?
Judge Hamilton, let me see. So the Housing Subcommittee already had its recommendations heard and voted on at the April 19th meeting. Subsequent to that meeting, some public comments and letters were received raising concern that the language of the resolution may have unintentionally been too broad. And so we met to address those issues and do have some clarifications or modifications to present. In addition, we also discussed education and training and disclosures. So we have some revised resolutions to change them. The main concern on the overbreadth of the language, unintentional overbreadth, was the Housing Committee was mostly focused on unlawful detainer actions. And that was the original intent, and that was the original discussion, is focused on eviction cases. In subcommittee, we did discuss broadening that, but our resolution was unclear as to what was being discussed with respect to eviction cases and what was for broader landlord-tenant cases. So, do you have the revised the red line to the resolution that we could bring up?
I didn't present this in red line. I can bring up the version that was in the, I just put the full one on here. And I
the one in the memo.
Right, I can bring that up.
I'm happy to walk through it. So this first, the bullet points, the changes from what was approved in April is in the second bullet point. It adds in unlawful detainer matters. That was what was intended, and so we're clarifying that. Also in the fourth bullet point, it's added, it said during trials, and we're adding during unlawful detainer trials. So what is intended is that these allowable things for paraprofessionals to do are in unlawful detainer matters. So to be clear, I'm going from the first bullet point, representation is limited to tenants and landlords who own no more than 2 units. That's for all housing matters. In unlawful detainer matters, paraprofessionals may provide in-court representation for motion hearings and default prove-ups. Paraprofessionals may not provide in-court representation in bench trials or jury trials. Again, that's for all housing matters. The fourth bullet point, during unlawful detainer trials, that's the addition, paraprofessionals may assist their clients by sitting at counsel table to provide advice and guidance and may respond to direct questions from the judge. Now, this fifth bullet point was added entirely, and again, to clarify, aside from unlawful detainer matters and small claims assistance, paraprofessionals may not represent or assist clients in court or out of court in superior court litigation in landlord-tenant disputes. So we're clarifying that this in-court representation relates just to unlawful detainer actions. It also bears clarifying that paraprofessionals will be able to assist clients in landlord-tenant matters, just not in litigation. So if there are non-litigation matters, like just questions about issues in landlord-tenant matters, habitability concerns, security deposit concerns, those they will be able to assist. It's just they won't be able to assist in litigation. So that's the clarification to address the overbreadth concerns. And for example, it was raised that with our prior language, potentially paraprofessionals would be able to bring affirmative litigation, including assisting people in court in non-unlawful detainer matters, and that was never what was intended. So this is clarification that still allows paraprofessionals to do some representation and assistance beyond unlawful detainer cases in non-litigation matters, but clarifies that what was intended here is for unlawful detainer matters. I think it would be good to vote on this separately. There were additional additions with respect to disclosures and education. Do you have that, Linda? So all this language was included in the last. This is not a red line. So all this is not new. It's the last three further resolved.
This is the last three. There was, I can bring up the red line version, if that would be helpful.
Thank you, Linda. Sorry about that. So this just explains what I was explaining about what the process was. But as I mentioned, this is a red line to the prior. And then we added these three at the end. I guess we can take it all at once. So this additional language here deals with advising clients. So the housing subcommittee identified that there are specific risks and complexity of cases with respect to subsidized housing, mobile homes, and rent control matters. So we wanted to make sure that paraprofessionals advise clients about those specific risks and that they could lose their housing. That's really the first one. The second one is disclosures specifically include that the paraprofessionals are not licensed to provide in-court representation at trial. And if the case goes to trial, having an attorney is strongly recommended. Again, these housing cases, these eviction cases are unique. They're very quick summary proceedings. And the view was that there's not going to be a lot of time to change courses and change plans. And so it needs to be clear right up front that if somebody received unlawful detainer complaint, that what a paraprofessional can and can't do, and the recommendation that if it's going to be a trial, that attorney is recommended. And finally, the last one is a recommendation for specific education and training related to the benefits of demanding a jury trial in unlawful detainer cases and regarding the rent control, subsidized housing, and mobile home issues that were identified as really specific, unique, and high risk. I think we have some hands raised. Judge Rubin?
Thank you. Can we go back to the last 3 red bullets? First of all, to Mr. Hardston, who's had to present twice today, but also to the whole committee, I just think it's been really great work. So I wanted to thank everybody for that. Secondly, on bullet 1, so the further resolved at the top of the page, I was looking at this through the lens of, let's say there's a lawsuit brought before me about this term not being followed. I, as a judge, would not know what provides specific information about the availability of free or low cost representation, et cetera, meant. In other words, is it enough to simply say that there's free or low cost representation? Do they have to be more specific about, here's some examples? I would have a really hard time with that. And I'm wondering if we couldn't be either just say, state that there is the availability of free or low cost representation, et cetera, or not. The only reason I say that is when you start obviously recommending specific people or giving out specific information, that opens up its own kettle of worms. In the last bullet or the last paragraph, it's a same observation. I think it's a great idea, but when we include specific information and required trainings regarding the benefits of demanding a jury trial, it seems if there is specific information that we want included, we should describe it. If the specific information is simply the required trainings, then it seems like it's maybe language that is creating more challenge than it's being clear. So that's just this judge's opinion, but otherwise I thought it's great work.
So let me just respond. Very, very helpful comments, Judge Rubin. I'll just explain that for both of these, really, these resolutions are intended to advise maybe the regulation subcommittee. So these are not the specific, I think, final language. This is going to be for licensing and regulation to include some specific language. So, for example, on the disclosures that are required, this is part of the regulation that we didn't get to yet on disclosures and informed consent. But this would say that at least for these types of matters, there needs to be more specific information. And so we're going to have to work on that language. This language wouldn't come before you as a judge, and probably none of the language would, because they're really rules of professional conduct that would go, discipline issues.
Well, given the process that this is yet to go through,
yes,
any language I've been seeing for the last few months will come before me in this. So
fair.
Not to rain on your parade, but thank you for the clarification.
Yes, and I would just say for the education as well, the idea is these are specific recommendations that I believe are going to be taken up with licensing on training with respect to what training is required. Steve?
Yeah, 2 points, one substantive, one not. The not substantive point is under the mobile home residency law, mobile home is 1 word, not 2 words. The substantive point is point 3 I'm opposed to. I don't know why we're singling out jury trial demands as opposed to anything else. And if there's gonna be training about the benefits, there should be training about the downside of it also, namely delay. And, this is a huge problem in LA Superior Court, where half of all jury trials are unlawful detainer actions. And, I don't want to take that program statewide. So I don't know why we're singling out just one thing for extra MCLE attention.
So I can address that, but Kim, did you want to address that? Is that why your hand's up?
No, I actually had a comment on this, Amos, sorry.
Okay, so the reason why we spoke about jury trials in particular and wanted it to be a required part of the training is because paraprofessionals will not be able to handle jury trials. but they are handling the answer. So there might be a difficult situation and maybe a conflict of interest with whether or not the paraprofessional demands a jury trial when they are not able to represent their clients at jury trial. And so we felt that it is important to identify this issue for training. We're not going to demand or require that a jury trial demand be made in every case. That wouldn't be appropriate, but that there be training on when it is appropriate to demand a jury trial. We thought in the benefits of demanding a jury trial is something that we considered and felt under the circumstances is appropriate. Kim, sorry to cut you off earlier.
No, that's okay. I just want to, you know my issue, Amos, with the first bullet of the new additional 3 items of further resolved, and the fact that they have to provide that contact information and having to keep that up for the paraprofessional. We've had this discussion in our reg committee side, so just wanted to bring my point up, and if at all possible, maybe split these 2, because it does seem like there's some concerns with the 3 additional ones. It's where I wouldn't have them with the first, but I just want to echo actually Judge Rubin's comment.
So, and just for clarification for everyone else, one of the rules of professional conduct 1.4.2 or 1.4.3 has a similar issue about disclosures, and the regulation subcommittee is.
And we obviously did not get, excuse me, obviously did not get to that today.
Yes, so that's going to be for individual vote, but there was some discussion and public comment that you heard today that some people feel like providing specific contact information for legal services or free legal services that may be available may be too burdensome for paraprofessionals. In the housing subcommittee, given the short timeline and the what's at risk, the housing subcommittee voted to include that contact information be provided, but it's an open issue or for further discussion by the full working group, whether that requirement should be required beyond the housing. Carolyn?
Okay, so yeah, this sort of brings up a point that I brought up earlier in 1.4.2 that's on our list to discuss further. So I have some ideas that hopefully I'll remember for that. This still contains, we're still letting people represent small, tiny landlords, mom and pop landlords, right?
Yes, so the restriction, this isn't new for today, but that was voted on and approved in April, was representation is limited to tenants and landlords who own no more than 2 units.
Okay. Yeah, I mean, I still have problems for my usual sense of things that it's not in court, but you fixed some of that. So my brain is trying to spin around what to do here.
Okay, Stephen?
Yeah, I would move that we table the 3rd point, and I'd like the judicial officers in the working group to call their friends in LA Superior Court and talk to them about jury trials in unlawful detainer cases, because I think private conversations will shed light on my concern.
What might I learn?
What you will learn is LA Superior Court is the largest trial court in the nation, and 1/2 of all jury trials are unlawful detainers. And it's a huge administrative headache for the court. That's what I believe you will learn.
Oh, Mr. Fleischman, with such my great respect for you, I will undertake that task.
Ira?
Yeah, I think Steve is right that some of the judges anyway will say that. And, but I don't think that that is something that should concern any tenant, maybe a landlord, because of course there would be delay, at least in Los Angeles, if a landlord demands jury trial, but tenants, that's a strategy. Tenants demand jury trials. And one reason is because the jury is more sympathetic usually than a judge in an eviction case. And another reason is that yes, it could cause delay. That's right. And there's the eviction system, many lawyers feel, is very unfair, very, very unfair to tenants. And if the court gets jammed up, that's not a problem for tenants. It's in fact it's an advantage for tenants.
But if I could just clarify, I don't think we should be debating whether or not there should be a constitutional right for jury trials in eviction proceedings. Or
I agree, but I don't.
Or whether tenants should or should not demand jury trials. The paraprofessionals will be practicing in this area, and they will not be allowed to represent tenants at jury trials. That's the issue that we are addressing. There should be training.
I agree, but the suggestion that one of us should call, anybody should call the LA Superior Court judges and find out why they don't like the demands for jury trials is not something that should affect our decision.
I agree, and that's what I'm clarifying. I don't think
All
the
right.
right to a jury trial or whether tenants should or should not demand jury trial is up for debate or vote here. I think the issue is whether paraprofessionals who will be allowed to help with answers, but will not be authorized to assist in jury trials, should be trained on the benefits of demanding a jury trial. And our recommendation is that it should be included in the training.
Yeah.
Sharon?
Yeah, I completely agree. And I think that this is a good resolution. I agree with Ira. We're looking at access to justice, and it's going to be tenants who are going to be hiring these paraprofessionals, and they would be at a great disadvantage if the paraprofessional was not educated on jury trial and did not tell them of that and didn't prepare them for that.
Carolyn?
Okay, so just to the comment that this is a strategy, I think makes light of what people are doing when they counter cross-claim for uninhabitability, mold, toxic chemicals, for nuisance, for harassment. I think those are very powerful and real tools that people need to be made aware of. So I just want to make sure that people don't make light of it. And this is, again, this is part of my, my ennui here, my concern with this. It's very serious, and especially in Los Angeles, I think, as people are mentioning, there's a lot of, again, this is from my heart, there are a lot of problems with apartments and housing. And I think everybody does have the right to a jury trial. And I think I was trying to look up, I'm not a landlord tenant attorney. I was trying to look up how fast you need to make a jury demand in unlawful detainers. And I think it's incredibly fast. And so, no, I think that we should not make light of this as some kind of strategy. There's real harm to people from mold and toxic chemicals and harassment. And that really needs to be thought through. So sorry, that's I just felt like I needed to stand up on my, I know some landlord tenant lawyers who do nothing but represent tenants. They work very hard. And they probably need this assistance, but they can't have it. It cannot be screwed up, or people will lose thousands and thousands of dollars. They'll lose their health. There is a Department of Health that they need to be made aware of, but this is part of my real concern with all of this and unlawful detainer. It's very, very complicated. Something's needed, but please don't make light of these cross claims. They're very, very serious for thousands of people in Los Angeles and elsewhere.
Stephen, is your hand up from before? Another comment?
No, I was just going to add, in addition to concerns about the impact on the courts from this, I would add, coming out of COVID, there's going to be an avalanche or tsunami or whatever, word you want to use of unlawful detainer cases that the courts are going to have to deal with. And, let's not make the administrative burden on the courts worse than it's already going to be.
Right. And again, I'll just point out that we're not advocating for changing any rights of tenants. We're just saying paraprofessionals would need to be trained.
But you're advocating only to educate people about the benefits of demanding a jury trial.
Did you have a amendment you would like to propose?
No, I want this out. But if you're going to do it about if it's going to go forward, it should be benefits and detriments.
Stephen, wouldn't it just be costs and benefits, or cost and benefit analysis?
Or pros and cons, or
pros and something.
But I don't know why of all the programs we're doing, this is the only one where we're singling out rights to jury trials or anything else for MCLE, a specific topic, which I'm telling you is controversial among court staff and judicial officers.
Amos, do you want to consider taking the resolution separately? So we can.
I don't mind that. So why don't we do the first one with the bullet point changes? So this doesn't have the red line in it, but the first motion I will go ahead and make is to include this first indented paragraph resolved as modified from the earlier approved in April, which clarifies the unlawful detainer and adds the 5th bullet point.
I'll second that.
And I think that it also includes these 2 paragraphs. I think that those were part of the original resolution.
They were, yeah, everything there was part of the original resolution except the final 3 paragraphs.
Right. So Amos, you moved that?
Yes.
Is that right?
This is,
And who seconded?
this
Kim?
is Kim, I seconded.
Okay.
Any further discussion about this? Okay, I'll call that vote.
Okay. Michon,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
Olvera,
Yes.
Robinson. I'm not sure if they're still here.
No, Nicole, she is not. She was catching a flight at 4:45, so she's not.
Okay. Judge Rubin,
Yes, thank you.
Shining,
No, and to save time for reasons that people can call me if they want me to elaborate on it.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambriz,
Can I abstain from this one?
yes.
Thank you.
Sorry. Judge Wiley.
Yes.
Okay, the motion carries.
Okay, and then the 3 final further resolves, I'll just take them separately. So the first further.
Hold on, let's get that up on the screen first, okay? Just so we can read along.
Right. It's this top one.
Correct. So this is to advise clients about the specific risks and complexity of rent control, subsidized housing, and mobile home cases.
You want to fix the spelling of mobile home?
I just want to ask if the work group hasn't voted on the work group's default position with regards to the specificity of a list of resources, because that was to be discussed today. Is it wise to take a vote on that here? Could be, I mean, if it is, that's fine. I was just putting that out there. So if not, then we should table it until the regulations committee has put on its resolutions.
So I think the question there will be if we want to include a similar requirement more broadly than housing. So I don't see any problem with doing this one first. It may or may not, it doesn't change how people might vote, I think, separately for the broader, but this is specifically with respect to cases, landlord-tenant cases involving rent control, subsidized, and mobile homes requiring these disclosures. That I think the Housing Committee was unanimous, including you, Fariba, I believe, that this is appropriate.
Because of the short timeline. Yeah.
Right. Julianne?
Is this the provision, the paragraph that Kim Kirkmeyer had a problem with because of the notice or the contact information?
Kim?
Yeah.
Yes, it is.
And what is your problem, Kim?
My concern,
You don't think that's specific enough?
I think it's too specific, Julie. I think by requiring them to have contact information, especially if we roll it over into like a rule of conduct for them to be get disciplined because they didn't have the right contact information, is problematic for me.
And I don't want to speak for Judge Rubin, but I think Judge Rubin also had a problem with the language. I don't know if he's here.
Are we voting on this one on its own? This first further resolved?
Yes.
Yeah. So folks can always vote no on it.
Correct. Julianne, did that answer your question?
It did. Thank you, Amos.
Carolyn?
I think this again begs the question, Julianne mentioned, I think 1.4.2. I think this is again cart before the horse. I think this is something that's very, very good. I just want to see what's meant by specific and have us work that out. Because this is too, yeah, I think Steve has problems with it, but I have problems the other way. We need to hash out 1.4.2 maybe with a list of what this means, because I have very specific things that I would make in that might get lost in translation.
I'm going to ask, I just realized my video was off, although I'm sure you recognize my voice at this point, sadly for all of you. I'm going to ask Amos to take these out of order, please. I think it may make sense to postpone just this one. If you could please go to the next two, see where we are on those, and then we'll circle back.
Yeah, happy to do that. So the next one is the one that's split between the two pages, starting at the top. So this one relates just to disclosures, specifically that include they're not paraprofessional is not licensed to provide in-court representation at trial, and if the case goes to trial, having an attorney is strongly recommended. So I'll move that this one be approved.
I'll second. This is Sharon.
And I don't see any hands, so Linda, you can go ahead and take a vote on that.
Okay. Bashan,
Yes.
Bernelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
Olvera,
Yes.
Judge Rubin.
I think he had to go just a minute ago.
Okay. Shining,
Yes.
Sarouche,
Yes.
Spiro,
Yes.
Torres Ambris.
Yes.
Motion carries.
Oh, I didn't vote. I'm sorry, Judge Wiley didn't vote.
Oh, I'm sorry. Oh, man. Judge Wiley.
It's just going to be everyone. She's going to not forget to take a vote.
Yeah.
Everyone gets
Yeah.
a turn.
Judge Wiley.
Yes, thank you.
Sorry.
That way, really, no one can get their feelings hurt if it's a different person each time. Okay, so Linda, when you can, if you could pull up that last paragraph for us to see.
Yes.
I think I see two hands. Should we do that before the motion?
Okay, and is this, just to give everyone a second to know what we're talking about here, this is the resolution that the licensing and oversight, the recommendation that the licensing and oversight committee ensure that the education program includes specific information and trainings regarding jury trials. And there was the suggestion that you change it from benefits to the costs and benefits, or the pros and cons, or something. I'll leave to you to think about what that is. Don't change anything yet, Linda. Let's wait to see what they want to do. And regarding rent control, subsidized housing, and mobile homes. Steve Fleischman?
Yeah, I made a motion to table this one. Judge Rubin, I understand he's not here anymore, but at least he indicated, yeah, he wouldn't mind talking to someone he knows in LA Superior Court. So, I'd like to see if there's a second, and encourage the judicial officers to talk to people they know on the bench in LA and get their views. And then we can circle back
So where I'm a little confused on this one, and I'll, again, as a non-voting member, I'm just gonna throw in my 2 cents here. If someone is being trained in unlawful detainer cases, it seems to me that they need to be trained in the entirety of what is an unlawful detainer case, even if they are only allowed to participate in portions to, a certain portion of it. Even if they can't do the jury trial, I would certainly think that the educational component would require understanding about jury trials and unlawful detainer cases. So I'm just a little, I'm a little confused as to what this adds or why there was the concern that this wouldn't be included. And Julie, I see your hand up.
Yeah, I would assume that would be included in what the training involves, but I would also say, why can't we just say required trainings regarding demanding a jury trial instead of benefits?
Exactly.
Just training regarding demanding a jury trial. That way.
Or just saying training regarding jury trials and unlawful detainer cases, rent control, subsidized housing, and mobile home issues.
Yes, I think that would be much easier to craft some curriculum around.
So from the subcommittee's perspective, I don't have any problem with deleting the benefits of. So it's just regarding demanding a jury trial. But again, demanding a jury trial is the specific issue that was raised because it's the jury trial demand that raised some concerns that paraprofessionals may not demand a jury trial if they're not authorized to handle a jury trial, whereas it still might be in the client's best interests to demand a jury trial. So that is the concern that was raised. And similarly, with regarding rent control, subsidized housing, and mobile home issues, I agree. Hopefully the training would have included that without this specific requirement, but those specific areas were raised as areas of concern with higher risk, that there needed to be some disclosures and trainings.
Can I speak to that?
Please.
I think we should keep that information in there, Amos. If we could just say regarding demanding a jury trial in unlawful detainer cases and regarding the things at the end. I think we keep it all because that's going to be of assistance when we're talking about what the world of information needs to be for that particular course. And I also think that it's fine to say something about it because that shows that at least we've contemplated and considered these issues because all of these are going to have to show up in the curriculum to say, while I'm teaching you about X, you can only do Y and Z. So you don't get to do everything that I'm teaching you about, but like Justice Petro said, they will need to understand the complete picture of what is available to their potential client.
Right. So Linda, go ahead and take out the benefits of, and
I object.
Oh, sorry, Ira, wait, hold on.
Okay, first of all, the reason, well, I'll get to this benefits thing first. It's a good point that Steve makes, why not the downsides? But so I would say the advantages and disadvantages to the client of demanding and the reason for that is if it just says regarding demanding jury trial, that could be how to demand the jury trial or the fact that you have to do it quickly. No, in this field of law in particular, it's extremely important to the tenant and probably to the landlord too, to know about the benefits and the advantages and disadvantages of doing it.
Okay, I think I'm going to have to, as chair, since we have 5 minutes left, I'm going to have to put a pause on this. Leah, I think there are some procedural issues that we needed to make sure to have a few minutes to discuss before the conclusion of today's meeting. Is that correct?
Yes. So you're saying you don't want to take a vote on the.
We're not ready to take a vote. There are more hands that are up and there may be some amendments to it. And so we are not able to take a vote we may not be able to take a vote by 5 o'clock, but certainly not with any time left for you to go over anything procedural.
Okay. So, Linda, I think we are going to move to next steps, which I'm not sure what we have up. And Brady, I really wanted to use these last couple of minutes to talk about finalizing the report and recommendations and the issue that we've discussed about subcommittee, working group members wanting to draft their own recommendations or dissenting opinions. So Brady, could you just share sort of what you laid out for me in terms of how working group members might go about doing that? I'm looking for Brady. Is he not here?
Was here.
Well, there we go. So that was the purpose. I will say.
So Leah, I think it's important. So I think this is important that the information get out to everyone. And so since Brady is not here, I'm going to ask that in the next few days, so that the people have plenty of time, that some kind of a memo or something go out to the committee about how it is that if someone has a dissenting view or alternate view, that they can memorialize that and have that put forward so that there is a record of it and an ability to consider it. I think it's very important that that be clear.
Right. And the particular issue that he was going to speak to is how working group members might want, how they can work together, how you can work together to do that outside of a publicly noticed meeting, if that's what you want to do. So I'll make sure to get that out in writing.
Okay.
Justice Petro, I assume committee members will also see a draft of the report.
Well, so let's go back, Leah. Leah, let's go back to the next step slides and have Leah address that.
Yes, originally you were going to see a draft of the report at the August meeting. I think the problem with that is we aren't going to be done. And now I'm fearful we're not even going to be done after the August meeting, but we weren't going to be done prior to the August meeting with action related to recommendations that might be included in the report. As you can see, for example, we've got to bring back disciplinary standards, a whole host of things in August. So now you will review a draft report. Linda, this meeting, review and finalize recommendations, or the first bullet in September, the first annotation is the new September meeting that Linda has worked to schedule. And that is where you will see a draft report.
And that's looking like it's going to be September 17th. So that's only a week, I believe, before the board meeting. We weren't able to schedule it for an earlier date.
Okay, so when I say that's when you'll see it, you will receive it in advance. We will do our best to get it out as shortly after the August 30th meeting as possible. So you won't see it for the first time on the 17th, obviously, but that will be the public meeting where we will be able to discuss the final report.
Leah, will I have the opportunity to review what I'll loosely call the majority report and provide comments on that in writing?
Ditto.
Yeah.
Okay.
Ditto. Like a movie.
How much time are we going to get for the final?
Well, I need to actually confer with Linda, because I don't think September 17th is actually going to work, because we have to post this for a board meeting. So I don't think the 17th is going to work. We have to post it for the board in advance. I mean, I would say you'll have a week at least. We need to figure out when we can schedule this September meeting.
And I think the issue with the September meeting might have been that only a couple of dates were circulated, if I remember correctly.
Those were the dates that both you, Justice Petro, and Leah were available.
Yeah, and like I said, I've got that time. So I think we need to confer, and I'll talk to Leah after this, but I think that was the issue. So we're going to need to redo that, because I agree that is too late in September.
Mm-hmm.
Okay, Lee, did you have any, sorry?
Justice Petra, just speaking
Yeah.
for myself, I don't think we got to any of the controversial rules today.
No.
I think that is an important topic which would merit a full meeting by itself. I know you probably already know this. I just wanted to get that off my chest.
Yeah, and I will note that our next meeting is a full day meeting. It is not one of these afternoon or morning meetings. But I mean, Leah and I will certainly discuss that as well. Okay, it's 5 o'clock. And I know there were some hands up, but that was from before. Do people have hands up? Anyone wish to say anything right now?
Yes, I do. Does the
Go for
Sorry, does the August meeting have a date on it yet?
August 31st.
Oh, yes.
You should have already
31st?
received an invitation and an Outlook invitation for that meeting.
Okay, I'm sorry, I got it. Thank you.
I just want to say thank you to the regulation subcommittee. And I
Yeah.
feel sadly we didn't get to the meat of the matter, but it's just an incredible amount of work that was done by that group. So
Yes.
thank you.
Exactly. Okay, everybody, it's 5 o'clock. Everyone should go. Thank you. I know actually Mondays feel like for some reason like it's a particularly hard day to have a longer meeting. Maybe it's just the beginning of the week. But thank you everyone for showing up and participating. And we'll see you at the end of August. And we're going to be circling with you sooner rather than later in regards to getting a September meeting date in place. All right, thanks everybody.
Thank you, staff.
Thank you. Thank you, everybody.
Bye, everyone.
Thank you.